information be included for eligibility to an appointment as an arbitrator, mediator, or adjudicator. And this is whether you are proficient in operating virtual platforms. ADR institutions should also be quick to offer courses on this subject to its panel members. Once this pre-qualification is demanded, literacy in the operation of virtual devices for ADR members will be substantially reduced. Secondly, even with the acceptance of the new norm, there is also corresponding demand to improve the operating process of virtual platforms. Currently, the popular devices used in ADR proceedings are Microsoft Teams, Zoom, and Webinar. They are excellent platforms for normal meetings and seminars and could display documents on the screen simultaneously with the speaker. Regrettably, the number of participants appearing on the screen is limited, particularly when documents are displayed. Then, of course, if you were to show multiple documents for comparison of contents, on the same screen, you may encounter limitations. I believe that these can be overcome by improved features in such programs when there is a demand. Currently, for hybrid ADR proceedings held in the AIAC that I experienced, there is a special room for this purpose, accompanied by virtual breakout rooms for more than one arbitrator to discuss among themselves in private. But apparently, if you need a larger room to accommodate more participants to comply with social distancing requirements, the accompanying virtual breakout room facility is not included as a feature. In future, perhaps, all venues for ADR hearings should have a comprehensive set of facilities for this purpose. Then, there were also occasional disruptions in the communication system, which were quickly rectified by the in-house technician. These, ladies and gentlemen, are teething problems. I'm confident that with the increased demand for such facilities, such hiccups will disappear. For now, I must give credit to AIAC and AIADR for its foresight in initiating such facilities prior to the pandemic. Since total digital hearing has yet to catch up, I would encourage all ADR institutions to proceed at great speed to improve their facilities to cater for the adoption of this new form of hearing. Ladies and gentlemen, still on this topic, I would like to highlight the need to adhere to certain protocol when conducting virtual or hybrid virtual proceedings. Virtual theoretically means that the participant can be anywhere. But one must bear in mind that, like physical ADR meetings and hearings, certain decorum and dress code is required to be maintained to give dignity to the process. It is not uncommon to observe a party in casual t-shirt or shorts appearing on screen, as you can observe from the slide. A quiet surrounding to conduct a virtual ADR is also necessary. You cannot have children running around and crying in the background, or the sound of pots and pans clanking to indicate lunch will soon be served. To remind us of the importance to observe decorum, One must not miss out recalling the infamous Australian Member of Parliament exposing himself on one occasion and urinating in another. Special areas should be designated to conduct such proceedings with lighting to focus on the face of the participant and video cameras properly positioned instead of exposing only half his face with the rest targeted at the ceiling fan. Ladies and gentlemen, these may be elementary, but when one is to embark on virtual ADR or hybrid kind of hearing, serious consideration must be given to selecting a designated area with least noise interference, equipped with adequate lighting and appropriate background display. The proceedings must not be too casual. Otherwise, the whole ADR process loses its impact and respect. Thirdly, ladies and gentlemen, ADR protocol should be designed or amended to accept notices and documents to be sent and received electronically as authentic, with digital awards containing verified signatures acceptable. Finally, ladies and gentlemen, to cater for anticipated increase in the workload of ADR cases, there is a need for ADR bodies and centers to devise fast-track procedure to meet this demand. I realize that no one-size procedure can fit all, but different type can be designed for different kind of matters. As I have said, what the aggrieved parties want during such time of crisis is a fast, economical, and legal binding process. To meet this challenge, new protocol with emphasis on strict timeline schedules to dispose of a contentious matter must quickly be drawn up and implemented. Without this, we will be remaining in the same spot as before. Like all universal disaster, ladies and gentlemen, the aftermath will change many things. There will be a new dawn, and things will never be the same again. Those engaged in ADR process must meet this challenge and prepare for the change as quickly as possible to survive. To encourage us to move forward in this direction, an observation by Justice Kirby, a retired Australian High Court judge, delivered at the turn of the last century, is most apt. And he said this: a lawyer from Dickens' time, walking out of Bleak House into a modern Australian court on an ordinary day, would see relatively few changes. Same wigs and robes, same elevated bench, and same sitting times. Very similar basic procedures of calling evidence and presenting arguments. Longer judgments, but still the same structure of facts, law, and conclusion. Contrast, if you will, the astonishment of physicians from Guy's Hospital in London, from the middle of the last century, wandering into the world of beepers and monitors, CAT scan, geometric tests, and automatic diagnosis of a modern Australian hospital. We have progressed in the law and in the courts, including the last 25 years, but not as much as other professions. Will it stay this way? Ladies and gentlemen, now with the onslaught of pandemic, My take is that it will not stay the same way, as Justice Kirby has posed in his challenge. Procedure and protocol will be changed to fast-track mode. Though the necessity of structure of facts, law, and conclusion approach to provide a solution to the dispute remain for method judgment and or awards will quicken the pace to release judges, arbitrators, and adjudicators from the chores of writing long judgments or awards to deal with more cases. With COVID-19 pandemic, the use of technology will expedite the clearance process. There will still be many challenges ahead of us, but in this time of crisis, ADR should lead the way to provide solution to overcome that. Thank you very much, ladies and gentlemen.
Thank you so much, Tan Sri James, for taking the time to speak to us today. For our next guest speaker, we would like to invite Professional Technologies Engineer Mr. Chu Kok Beng, Champion of Professional Services Productivity Nexus, PSPN, and the Malaysia Productivity Cooperation, MPC.
Good afternoon. Can you hear me? Yeah, okay. To show that actually we are working from home, this is actually the background is my house where I'm talking from. Okay. Okay. First of all, yang berbahagia, Professor Sundram Raju, President of AI ADR, yang berbahagia Tan Sri James Fong, who gave a very good keynote address, and ladies and gentlemen, distinguished speakers, happy afternoon to all of you. On behalf of the Professional Services Productivity Nexus, Malaysia, and the Malaysian Productivity Cooperation, MPC, I would like to congratulate AI ADR for organizing this afternoon's event that will certainly enlighten the participants towards the application and development of ad hoc arbitration. The active involvement and collaborative efforts amongst ADR petitioners, taking into consideration the advice that was given by the Dr. Tan Sri James, will, I'm sure, ensure the productivity improvement in the legal fraternity. I'm sure that this will be realized through the utilization of ad hoc arbitration as a method of dispute resolution in public at large. One observation I made was when I was invited, the word AIADR is straight away drew my attention. AI not standing for Asia Institute, but more on artificial intelligence. So I suppose this is one area of technology which could be employed in the future to expedite all these cases of ad hoc dispute resolution. I hope that later on in the discussion, they will find a place to utilizing technology such as artificial intelligence and also blockchain to assist all the procedural aspect. They can shorten the process of dispute resolution. The services sector, as we all are aware, is a key component to national economic well-being, and it's a major contributor to the employment of Malaysians. Malaysia aspires to establish a more vibrant and resilient services economy consisting of more productive and competitive market to build upon the continued growth of the sector through a focus on high value added activities. So the recent COVID-19 outbreak has proven to be a strain on the global economy, and businesses are growing increasingly concerned about surviving these extremely challenging times and in order to sustain the business. Hence, this ad hoc arbitration forum brought by AI-ADR, I'm sure will play an important role for ease of doing business, especially among the small and fragmented Malaysian professional services providers. In MPC, we are putting a lot of emphasis on this, and I'm happy that the legal profession of Malaysia is playing an active role. So particularly represented by Dr. Ricky Tan. So in closing, I would like to express my sincere thanks to AI-ADR in making this forum a reality. With goodwill, clear ambition, and strong commitment to work together, I'm confident that every step taken towards ease of doing business using an ad hoc arbitration will increase our business capacity. And sincerely again, to all of you for being here this afternoon, I wish you all have a very fruitful time and be able to provide the solutions to have all these dispute resolutions which are accumulating settled as quickly as possible. With that, thank you very much. Bye-bye.
Thank you, professional technologist Mr. Chu, for the speech. Without further ado, to kick off this gracious event, we would like to invite Ms. Ramit Kaur, Chairperson of the Asian Institute of Alternative Dispute Resolution, Professional Development and Education Committee.
Thank you. Your Excellencies, Honorable Delegates, ladies and gentlemen. On behalf of the AI-ADR's Professional Development and Education Committee as a whole, I'm delighted to announce the launch of AI-ADR ad hoc arbitration rules on appointment, case administration, and financial management 2021. In its 2021 International Arbitration Survey titled Adapting Arbitration to a Changing World, the Whiting case reported, and I quote, interviewees valued the procedural flexibility offered by ad hoc arbitration, which they felt enhanced party autonomy compared to institutional arbitration. This emphasis on party autonomy throughout the arbitration process was a recurring theme in interviews. A number of interviewees also highlighted the popularity of ad hoc arbitration for resolving in sectors such as the maritime industry and commodity markets. As one interviewee specializing in maritime disputes explained, parties want a dispute resolution mechanism that was developed by their sector, for their sector, and conducted by practitioners from their sector. We at the AI-ADR firmly believe that the launch of these rules will assist greatly in providing just enough structure for an ad hoc arbitration to function as efficiently as an administered arbitration. It is also tailored to accommodate the needs of parties who are suffering from financial distress or for those who are making small claims. Our experiences tells us that cross-border disputes involves the added requirement to appreciate different culture, nationalities, and legal systems. More importantly, language barriers. In an effort to cater for users of the rules Asian-wide and worldwide, our rules are available in English and Chinese for now. The rules also provides a transparent pricing structure with currency of party's choice. These included Ringgit Malaysia, Renminbi, and US dollar, allowing a party to eliminate the burden of paying extra charges for currency conversion. At AI-ADR, it is our pleasure to be recognized as a repertoire of global jurisprudence, formed by professional membership, recognized by international institutions, striving for the advancement of alternative dispute resolution methodologies for amicable conflicts management and effective dispute resolution. It is our vision that with the publication of these rules, our members would be able to better minimize and mitigate the impact of the pandemic, supporting international commercial activities with prevention in mind, but inevitably a swift, affordable dispute resolution service. Finally, we are confident that the Ad hoc Arbitration Rules 2021 will mark a beginning of an accelerated growth in ad hoc arbitration in this region to enable parties to customize their unique approaches to dispute resolution that is most suited for their businesses and industry. Thank you, and I wish you a wonderful and fruitful session this afternoon.
Thank you so much, Ms. Ramit, for your speech. And now for the introduction of the AIADR Ad hoc Arbitration Rules on Appointment, Case Administration and Financial Management 2021, we have prepared a launching video. Please enjoy. It is my pleasure now to move to our first panel discussion of the day, an era of arbitration, framework and evolution of ad hoc arbitration. This panel discussion aimed at introducing the framework of ad hoc arbitration. We are honored to welcome as moderator, Mr. Ish Jain. He is an international arbitrator and a senior partner at Regis Legal LLP. He is also empaneled as arbitrator and emergency arbitrator in several prestigious global institutes in the United Kingdom and across the South Asian region. Since 2004, he commenced gaining experience in arbitration and litigation, even prior to being formally qualified as a lawyer. Mr. Ish continues to serve as an eminent arbitrator in the industry and possesses expertise in areas of securities, technology, aerospace, finance, corporate, commercial, maritime, debt recovery, and art. Mr. Ish has also judged more than 11 jurisdictions, including the William C. Vismut and the Vis East Moot competition. He has been honored as the Future Legal Leaders Award by the Indian Business Law Journal, Vantage Asia, Hong Kong, and the Indian Achiever Award for Domestic and International Arbitration by the Indian Achievers Forum and CSR Times. Ladies and gentlemen, please welcome Mr. Ish.
Hello, everyone. Well, since we're running short on time, as I've been informed, let's quickly get on to our panelists. Mr. Roland Cheng. Are you? Yes. Next would be Ms. Karen. And Mr. Anand. Right. Just to briefly introduce our panelist, Mr. Roland was admitted as a barrister at law in Lincoln's in November 1990. He's commenced his legal practice under the name of Roland Cheng almost 28 years ago. He's also a fellow at the Chartered Institute of Arbitrators in the UK since April 2015. He is one of the panel adjudicators at the AIAC since July 2014. So welcome, Roland.
Thank you. Glad to be here.
Now, Ms. Karen, she's been practicing for more than 30 years, and she has experience in the domestic and international commercial arbitration, both as a counsel as well as an arbitrator. In 2017, she was also appointed and is a member of the AIAC panel of experts, advising AIAC in the new standard forms of building contracts, which was launched in August 2017. and the Jamaican International Arbitration Center. Karen is also the past president of the Chartered Institute of Arbitrators and is a fellow at the AIADR. So, welcome, Karen. Moving on to, sorry, Karen, you were saying something?
I said good morning. Good morning from London.
Very well. Mr. Anand, good morning. Mr. Anand has acted as an expert witness on various construction arbitration cases and court cases. He has also acted as an arbitrator under the ad hoc as well as administered arbitration. He has received various adjudicator and DAB member commissions. Mr. Anand is a past chairman of the Chartered Institute of Arbitrators Mauritius branch. So, welcome, Mr. Anand.
Thank you, Ish. Thank you, attendees.
Now, good morning and good afternoon and good evening to all our participants and esteemed panelists. Without wasting much time, let's dive into the topic we'll be covering today. That is the evolution of ad hoc arbitrations. Ad hoc arbitrations have been defined as arbitrations that are conducted without the involvement of any arbitral institutions and are generally conducted without the benefit of an appointing or an administrative authority or pre-existing rules, save and except the courts or the national arbitration laws. While it offers parties and arbitrators a flexibility to conduct arbitrations, it also has less external support for the process. It can be quicker than the institutional arbitration, but not if the parties run into difficulties with the appointment or the conduct of the tribunal. The only remedy available to the parties is the interference from the court. It may at times be cost effective for an ad hoc arbitrations to be conducted, but it might also cause delay due to lack of cooperation amongst the parties during the process. With all these ifs and buts governing the ad hoc arbitration, it becomes pertinent to understand the evolution of the ad hoc arbitrations. Let's take advantage of the experience of our panel guests to understand ad hoc arbitrations. Roland, I would like to begin with you. Could you briefly tell us the evolution of ad hoc arbitrations and whether this process is still prevalent today?
Fine. The evolution of ad hoc arbitration actually is something which uh, goes back to long time ago. If I may just share this screen so that you can see this particular slide that I wanted to share with you. I'm not able to share yet. Can you allow me to share screen? I'm not allowed to share screen at the moment.
I think we'll have to ask one of the, okay, it's disabled from my end as well.
Okay, doesn't matter then.
Yes.
You see, when we look at ad hoc arbitration, it sounds like a very big word, but actually arbitration goes back to so long ago that in one article that I have read, it says that probably Solomon was one of the first arbitrators. And when he did arbitration, as those who are well aware of it, he invented these rules whereby parties are able to explain about the situation, and they eventually were able to resolve the situation because their side of the argument was clearly exposed. Say, for example, in the case of Solomon and these two women who both claimed that they were the mothers, and it was obvious who was the mother. Now, of course, arbitration, on the other hand, is also something that we need to be aware of, that when you look at ad hoc arbitration, it must be among equals. As there's one saying, I'm not sure whether or not I can share screen now. Yes, I can share screen now. Okay, can you see that? Yes, one of the earliest, can you confirm whether or not you are seeing this screen?
Yes, Roland, we can see the screen.
Okay. Now, if you see one of these, the first earliest arbitrators was Solomon himself. And this is taken from this article. But arbitration, whether or not it is institutional or ad hoc, must be between equals. And this is a quotation taken that arbitration is actually believed in, but it is not in an arbitration whereby it's between the lion and the lamb, in which the lamb is in the morning found inside the lion. So this is a rather drastic way of putting it, but that is what arbitration is. So that is insofar as the history of arbitration is concerned. But arbitration continues even outside, because as long as the parties themselves find that they have confidence in one arbitrator and that he is able to do the job, that would be arbitration. And it continues every day in so many disputes that we don't normally hear of. And that's what I want to say.
Thank you, Roland. I think I completely agree with you. Moving on to my next question. Before we spearhead into the different components and factors which govern the ad hoc arbitrations, let us first understand what makes ad hoc arbitration still, the favorable mechanism in certain jurisdictions. Anand, what's your take on this?
Thank you, Ish. I think, I would agree with Roland, but I think what we should look at is what's the definition of ad hoc arbitration. A simple definition is that it's conducted independently by the parties who are themselves responsible for deciding on the forum, the number of arbitrators, procedure that will be followed, and all other aspects of administering the arbitration itself. Arbitration, in fact, can be traced as long back as Solomon, as Roland mentioned, but it actually gained an official definition in the Geneva 1961 Convention, Article 1(2)b, where ad hoc arbitration is defined as settlement by arbitrators appointed for each case. Well, since then, I mean, the ad hoc arbitration is in fact the most favorable mechanism because firstly, it is suitable for all types of claims. If ad hoc arbitrations are properly framed, they should be in fact less expensive than corresponding institutional arbitration. Here, the parties only pay the fees of the arbitral tribunal, the lawyers or representative, and the costs incurred for conducting the arbitration, i.e. expenses of venue, charges, etc., etc. They do not have to pay the arbitration institution for administration fees, which if the amount in dispute can be quite considerable, it becomes then prohibitively expensive. The parties here also have the flexibility of holding the hearing at any venue. You normally don't do it at the institutional venue provided for the process. In fact, bigger corporations find ad hoc arbitration they have a preference for that because they often have large and sophisticated in-house counsel departments and have accrued experience in managing arbitration proceedings. Ad hoc arbitration, in fact, may be designed according to the requirements of the parties, particularly where the stakes are large or even where state or government agency is involved. The parties are in a position to devise procedure fair and suitable by adopting or adapting to the suitable rules. In fact, state parties may prefer ad hoc arbitration if they are concerned that a submission to institutional arbitration devalues their sovereignty, particularly when disputes involve public interest and large sums of public money. They would want, of course, the flexibility to define issues quickly, but also to adopt acceptable procedures. For example, they may wish to file simultaneous pleadings, as neither party would want to be a respondent, as they both believe they have justifiable claims. In ad hoc arbitration, parties have to agree the scale of remuneration with the arbitral panel and agree fees directly with the arbitral tribunal, who will have to collect the money directly from the parties. This is a bit awkward sometimes, and there will obviously be some degree of distraction, which may lead to awkwardness for all concerned. There is no opportunity for negotiation of fees in institutional arbitration, on the other hand, which requires a party to pay arbitration tribunal fees as stipulated by the institution. So in ad hoc arbitration, parties negotiate and settle fees with arbitrators. And of course, this allows them the opportunity of negotiating a reduction in fees. In fact, if you compare ad hoc arbitration with institutional arbitration, one writer has actually said these are set meals. Institutional arbitration is already cooked for you and presented on a plate with very set ingredients on the plate. While ad hoc arbitration, there is what we call dining a la carte. So you choose which one you want and adapt it at your convenience. So Ish, this is what I would say at the moment for ad hoc arbitration.
Well, I think, Anand, you've aptly put out why ad hoc arbitration is still the preferred and the favored method in some of the jurisdiction and in most of the cases. It's actually interesting to note that the London Maritime Arbitrators Association's report, I think it was released in somewhere 30th March 2020. It showed that there is a 15% increase in ad hoc arbitration cases between 2018 to 2020. So yes, it appears to be the most preferred method in some of the jurisdictions. Well, now that we've glanced how ad hoc arbitration is still not without its advantages, but we are also equally aware that the institutional arbitrations have created some sort of a niche in the international arbitration arena, especially in Singapore, Hong Kong, Malaysia, which is turning out to be the desired seat by the parties seeking institutional arbitration. Anand, would you have some insights on that? What's your opinion on the introduction of the institutional arbitration, despite ad hoc arbitrations being prevalent for several decades now?
Ish, there is, of course, various reasons for introduction of institutional arbitration. As you say, despite ad hoc arbitration being there for so long, there are several reasons for this preference for a preference for institutional arbitration. Firstly, it's the prestige we've involved with an institution. It tends to lend political and moral weights to awards. Given that, of course, with institutional arbitrations, there is, under the New York Convention, you can have an ease to enforce your award anywhere you want. But in ad hoc arbitration, that might be difficult, given if you haven't carried out certain things, or depends on your law of the seats, etc. So practical advantage of institutional arbitration is that there is what we call a comfort element in an arbitration that is sometimes mentioned in the course of the arbitral institution existence. So such comfort from a particular institution experience as well as its reputation. But more practically, because institutional rules are designed to regulate the proceedings comprehensively from beginning to end, the institutions are better suited to cater for contingencies that might arise. Even as sometimes happens, a party fails or refuses to cooperate, and you see that the institution rules deals with that. And by incorporating institutional rules into the contract, contracting parties also avoid the time and expense of drafting a suitable ad hoc clause, which we know can be a booby trap sometimes. Also, institutional arbitration, and this is where arbitrators like that, because it actually devolves them from assuming arbitrators administrative responsibility for the arbitration, and they take care of fundamental aspects of the procedure. So the fees and expenses of the arbitration are with varying degrees of uncertainty, They are regulated, and some arbitral institutions independently vet awards to ensure enforceability. For example, the ICC. So ad hoc arbitration lacks the support net of an institution. And of course, it depends on its full effectiveness on the spirit of cooperation between the parties, which is usually lacking by the time disputes have arisen. You will be you will be glad to know that this White and Case survey 2021, in fact, proves that institutional arbitration is becoming very popular, although ad hoc is also, in certain quarters, very popular. Like you mentioned, maritime arbitration in London, for example, they're all ad hoc arbitration. And this is a good sign that ad hoc arbitration are there, but institutional arbitration is gaining ground, principally because you are what we call a set meal. There are set rules, there are set procedures, and everything is provided for. And it gives a lot of autonomy to the parties as well as the arbitrator. So this is why I think the institutional arbitration has taken off, despite ad hoc arbitration being there for a long time.
Thank you, Anand. Well, now that we've had our share of how the introduction of the institutional arbitrations have taken place as compared to the ad hoc arbitrations, let us try to understand the distinguishing factors. And the first thing that comes to my mind, as Roland had earlier mentioned, is the appointment of the arbitrators. Roland, what's your view on the method of appointing the arbitrators in an ad hoc arbitration, as opposed to the institutional arbitration?
Insofar as ad hoc arbitration is concerned, it all depends on the parties themselves. And normally it will be somebody that is well known in the community, who has done arbitration and therefore stands out and has all the qualities of an arbitrator insofar as the parties are concerned. And most of the time, parties are concerned that this arbitrator that they intend to choose is somebody who is well versed in his expertise, and somebody who is not partial, and that his awards do stand up in a court of law. These are the main basic criteria for choosing an arbitrator. And the advantages of this nowadays is that because if you have such an arbitrator, you can actually propose his name. If you are not too comfortable with ad hoc arbitration, to the arbitrating body to have him appointed as your arbitrator, or rather your preferred arbitrator, and to be governing in accordance with that arbitration institute's rules. So using this method, you have the advantages of both the ad hoc arbitration of having an arbitrator of your choice, and also having the institutional rules. Of course, the disadvantage in such a manner is still cost. But I actually think that if you have a client who is worried about costs, then you have to be also thinking about how he's going to be using that same approach when it comes to payment of the arbitrator's costs. So that is a factor that goes both ways, so that the real matter of the cost of the arbitrator or of the institution itself should not be the primary factor, and that if anybody comes to raise this issue of the cost only of the arbitrator or the arbitrating institute, that is something which anyone should bring it to their knowledge, that the cost itself is a very, very minor component. Because if you imagine that having gone through all the process of arbitration itself, and then you find that the award cannot stand up in a court of law in enforcement, so much time and effort will be wasted. And so therefore that the cost itself would be quite minimal. The other thing that is always very important in appointing the arbitrator is his track record. Now, because arbitration is a private matter between two parties, normally the arbitration award itself is not known. But of course, if the matter goes to court, then the relative attributes of that arbitrator, the strength and his thoughts in that arbitration process becomes known. So most of the time, because of the secrecy nature of the arbitration itself, we will not be able to know what the arbitrator's background is. So with the advantage of the law reports now, a good arbitrator and the fact of his track record will only be known if his case goes to court and stands up in court. So I think that these are matters which any person who is thinking of ad hoc arbitration, you should consider these, because having a good, solid arbitrator whose award is upheld in the court is a very important consideration. That's all.
All right. Thanks, Roland. Karen, you are one of the most experienced persons who could, tell us about the appointment of an arbitrator in ad hoc arbitrations. You have 30 years of experience as a counsel as well as an arbitrator. What's your take on the method of appointment of an arbitrator in ad hoc arbitrations? Is there any scope for change or improvement in these methods?
Well, Ish, as you said, one of the key features of ad hoc arbitration is that the parties appoint the arbitrator, or at least they agree on the method of appointment for the arbitrator. And that is absolutely key, because an ad hoc arbitration agreement might not necessarily contain an appointing mechanism. And in fact, oftentimes it doesn't. And that takes us, as we all know, straight into the arms of the court and delays everything and causes all kinds of problems. So if parties are embarking on ad hoc arbitration, they must either have confidence to agree in a person, as Roland has just been discussing, or they must insert into their basic arbitration agreement a means to appoint an arbitrator. And one of the first things you see in the AIADR's new rules, ad hoc arbitration rules, is that they actually provide that supporting mechanism so that if the parties don't agree, and let's face it, 30 years of experience, you don't need to know that when parties are in dispute, they're not going to agree on the appointment of the arbitrator. So to have a fallback mechanism in your arbitration agreement to go to a local appointing authority with a good panel of established arbitrators who hopefully will deliver you a binding and enforceable arbitration award, it is a critical thing. So I think that's really important. I mean, Roland spoke about ad hoc arbitration and the history of arbitration. I mean, ad hoc arbitration is the history of arbitration. Institutional arbitration is a very 20th century invention. And one of the things we haven't really discussed, and I'm sure we don't have time to discuss, but our delegates need to understand, is that there is no clear-cut ad hoc arbitration and institutional arbitration. There's no line down the middle which separates one from the other. You can have all kinds of hybrid situations. And again, referring to these rules, these new rules that AIADR has just produced, they actually pick up on all these features so that in an essentially ad hoc arbitration, they have, and we're starting with, as you say, and we're going to talk about other things, they have, first of all, a means to appoint an arbitrator and to deal with challenges from arbitrators. That's extremely important. Now, can we do better? Is there room for improvement in the appointment of arbitrators? Well, there's always room for improvement. And really, I mean, I would say in terms of arbitration and in terms of support for appointment of arbitrators, training and education are the key features. If you are having an ad hoc arbitration, you want to make an appointment and you want to be sure that you get somebody that knows what they're doing, the first thing you can look at, and you know yourself, you're a fellow of the Chartered Institute of Arbitrators, it says so on the screen, but you need to look to see if people have training, if they have qualifications. We all have qualifications as arbitrators, and you also then need to look at experience. So yeah, there is that room for experience. There is room for bodies, whether they're institutions or other educating bodies, to do a lot to improve the quality of arbitrators. And one way that you can improve yourself as an arbitrator, of course, is doing what we're doing now. It's engaging at congresses, engaging at conferences, listening to the views of your colleagues in the profession. The improvements that I'm talking about here are not tied to ad hoc arbitration. I mean, they're equally applicable to institutional arbitration. I don't know whether I can add anything more to that right now. So.
If I can just interject, Roland also referred to the cost, the difference in the cost of arbitration proceedings between the ad hoc and the institutional. What's your take on the difference in the cost? Does it have any implications?
Well, given the setting of this conference, cost is obviously a factor. We're coming out of a pandemic, businesses are stretched, and they're going to be looking at how best they can spend their money. And if they have disputes that need resolving, they're going to be very cost conscious. One of the things, again, with these AIDR rules, if you are looking for the appointment of an arbitrator, you could also pick up on the scales of fees. In ad hoc arbitration, there's no regulation as such of fees. You have to pay the market rate. If you're worried about cost control, then the institutional scale fees and the institutional panels would probably be a good reference point to go and find your arbitrator there. Because whatever the market rate is, if you're appointed through an institution, then you are likely to have to adhere to the institutional scale fees. That doesn't mean you have to buy into the rest of the institutional package, but it is a good way to regulate the arbitrator's costs. And the main thing, of course, of ad hoc, the main advantage of ad hoc over institutional here is that you are not paying for the costs of the administration of the arbitration by the institution. But that can be a short-term gain, because if you don't have an arbitrator that's capable of firmly regulating the procedure in the arbitration, the procedure may derail and you may end up spending a whole lot more money. So having confidence in your appointment or your appointing authority and then availing yourself of the scale fees is probably quite a good way to go. And quite important, as I say, coming out of the pandemic, especially for small and medium-sized enterprises with disputes to settle.
Thank you, Karen. I don't think I could, I couldn't have agreed more to what you said. But coming back to the point that you made earlier, do you think in an ad hoc arbitrations where you would have to approach a court for an appointment, it would consume more time due to the frequent deadlocks and the non-cooperation between the parties? I mean, what does the new AIADR rules change in this respect?
My personal experience, and it comes from working extensively in the Caribbean, but my personal experience is that, for example, and this particularly exemplifies the ad hoc institutional arbitration route, is that institutions do not wish to go down, for example, the ICC route, not because it's not excellent. I mean, unquestionably, it's a very good arbitration institution with excellent rules and all of those kinds of things. But the cost to many people of securing an ICC appointment and having an ICC administered arbitration is extraordinary in terms of their ability to fund the dispute resolution process. So what they do is they replace the ICC clause in, for example, a FIDIC building contract with an ad hoc arbitration clause, and an ad hoc arbitration clause with no default appointing mechanism, so that if the parties don't agree, and when they're in dispute, they don't agree, when they don't agree, you must go to the court. And then all of the benefits you have of going to arbitration and having AIADR or another institution give you an arbitrator in a week or two, that's lost completely. And you're thrown back into the delays of court proceedings, delays which are worse than ever everywhere in the world now. As Tan Sri Fung said in his speech, you know, there is a backlog. Actually now getting in front of a judge for any reason at all is going to be difficult. And if you've replaced your institutional appointing, your default appointing mechanism, with no mechanism at all, so you must go to court, you can be years getting the appointment of an arbitrator, which is a disaster, frankly, for people trying to get a dispute resolved. But it's a respondent's charter, really, that kind of arbitration clause. So I think it's very important that people, when they settle on ad hoc arbitration, at the very least, put in a default appointing mechanism.
Thank you, Karen. You know, gauging by what you said, would you then say that, you know, since ad hoc arbitrations don't have a definitive framework, it's a drawback for ad hoc arbitrations?
Well, it can be if parties, if it's the 5 to midnight clause in your trade contract and nobody gives it any thought, it can be disastrous. If it's thought through, no, I mean, it has all the flexibility that Anand was talking about. And I mean, it can be tailored to suit the moment, to suit the particular dispute. And that's why we see maritime arbitration, we see GAFTA arbitrations, commodity arbitrations. They are very, very successful because they have developed their own rules and processes that are particular to their sector. And that is the real benefit of ad hoc. You need a little bit of help at different points for the key features, but you don't need the thing to be overtaken necessarily by a generic institution. So having your flexibility to devise a process very specific to your dispute is a very good benefit of ad hoc arbitration, but it has to be looked at responsibly. You can't just do it on the hoof, because once you're in dispute, agreement on any other aspect of the arbitration is also going to be difficult to secure.
Understood. Well, moving on to the next issue, how would you gauge confidentiality, Karen? Especially, you know, confidentiality is one of the pillars for arbitration, and you know, one could say that, you know, in an ad hoc arbitration, confidentiality is more secure, that the data are more private because it's between the three parties. Whereas when it's an institutional arbitration, you have the secretariat, you have the registrar, you have, you know, multiple people involved in the arbitration institution who have access to those confidential data during the arbitration process.
Yes, confidentiality is honored more in the breach than in adherence, in my experience, and that's everywhere. One of the best ways, I mean, I agree with what you said, because actually, if there's only 3 parties, the risk of leakage is reduced. Although I must say, I've not got any experience of institutional arbitrations being leaked by institutions. But what is popular these days is that institutions will provide yearbooks of arbitration decisions and they'll anonymize them. But actually, if you're in the know, you know exactly what the arbitration is about. You may know the parties and you understand the outcome. So there is that, it's not risk, it's almost certain if you've got an interesting case, is that there's likelihood that something will come out of it and be put into the public domain. With ad hoc, there is a reduced risk, but again, when I was talking about responsible drafting of arbitration agreements, one of the things that parties might consider, and flexibility allows them to do this, when they're considering an ad hoc arbitration, they may write in an express obligation for confidentiality. And that would be particularly important in an international case, because confidentiality means something in some jurisdictions and it means nothing at all in others. So you can secure the confidentiality more if you responsibly look at your clause and you put in an express obligation. I think that's quite important. I don't think I want to say any more about that at the moment. I'm sure you've got some other questions, but I think we'll come back to it when we're talking about the other issues.
Well, I would like to now go to Anand. I want Anand's take on what you just said. Anand, as Karen just said, ad hoc arbitration always has a favorable mechanism when it's allowed more flexibility and power to the parties in the past. But as we discussed, it also gets misused due to constant non-cooperations between the parties, and that's the case when there is a dispute. What are the practical difficulties as a counsel or as an arbitrator that you faced in situations where either party is not willing to cooperate in an ad hoc arbitration?
Ish, very good question, because this comes up very often in ad hoc arbitration. Well, the effectiveness of ad hoc arbitration depends, as you say, on party autonomy. It depends on the party's willingness to agree the procedures upon the procedures at the time they are already in dispute. But as just Karen mentioned, if you are already in dispute earlier, you tend to find many points where you disagree. And that's where cooperation between the parties do not happen, and they do not facilitate the arbitration. So there could be a lot of loss of time in resolving the issues. And practical difficulties may be that the arbitration makes the rules as it goes along, or another way around, which is a lot better, is for parties to get around these issues by adopting ready-made arbitration rules, where parties can avoid such disagreements and avoid delays if they agree to conduct arbitration, for example, under certain rules, for example, under the AI-ADR ad hoc rules, or even the UNCITRAL selected arbitration rules. For example, Article 2A of the UNCITRAL model law applies to ad hoc as well as institutional arbitration, and they are very popular. I mean, the White and Case survey showed the most popular rules to be shows a great extent of preference for adopting UNCITRAL rules. So if we don't have rules, and as Karen mentioned, that parties often disagree, you will end up in court. And of course, we'll have to determine the contested interlocutory issues, which may delay, in fact, the overall arbitration proceedings. So delays will arise, costs will increase, and you will have great difficulty, maybe if, as you say, if the arbitrators have limited knowledge or do not handle the case properly, they can be in a twist. So the potential of arbitration or ad hoc or institution is the ability to delay, such as the ability to delay proceedings by counsels or parties, are more likely to arise in ad hoc arbitration if there are no general rules. Having said that, in fact, the additional layer of bureaucracy imposed by institutional arbitration may also cause delay, and inevitably additional fees that become payable. Although the arbitration fees are reduced because they have less administration to do, that is theoretically, the fees of the institution can add, in fact, a significant amount to the overall cost. So this is particularly so when there's a large amount involved. So users of ad hoc arbitration should value the use of proxy. Of course, because when we talk about arbitration, we talk about parties' autonomy. So there should be procedural flexibility in which they feel enhanced when compared to institutional arbitration. So you will see that's why, for example, you mentioned that shipping and commodities sectors have certain rules, and they are because they are sophisticated users of arbitration. And this is where things get, all the difficulties are ironed out because people know exactly what to do. The other problem that you may find in ad hoc arbitration is that, of course, awards are subject to appeal under the lex arbitrae. and sometimes may be refused recognition and enforcement under the limited grounds of the Article 5 of the New York Convention. So this, in fact, adds, in the New York Convention, adds an additional layer of scrutiny that ensures the award compliance with essential guarantees of due process. So back to you, Ash.
Thank you, Anand. In fact, we have a question. You spoke about the enforcement of the awards in an ad hoc arbitration. We have a question from one of the attendees, and he's asking, what is the legal enforcement of an order passed under ad hoc arbitration? I presume he means the award passed under ad hoc arbitration. And what is the legal enforcement of the provision of law applicable for execution of an order passed under ad hoc arbitration? Would you want to show some light on that?
Well, I'll try that. Let's look at the ad hoc arbitration first. If you look at any, I mean, it will have the an award issued by an arbitral tribunal, an ad hoc arbitration tribunal, will obviously be able to be applied in any court of law under the lex arbitrae, or it can be appealed in the same lex arbitrae. But however, it will, depending on the law of the country in regards to whether it is pro arbitration or otherwise, you might find some issues being able to sort of the court opening up issues on its merits. But if you have pro arbitration courts, obviously that will be ironed out. So any appeal or any award in terms of orders, etc., as well, would be able to be, the parties would be able to approach the courts under the lex arbitrae and either enforce the order or enforce the award. Now, normally, when we talk about international arbitration, you would have to enforce the award under the Article 5 of the New York Convention, as I mentioned earlier. So there are Article 5 has different set of rules that the award must be scrutinized under. So again, the arbitrator must be careful that he has followed all the procedure and everything is in place so that the award is not thrown out.
Okay, thank you, Anand. Roland, you are from Malaysia. If you can give us some insights on this very issue of enforceability in Malaysia, which are the two types of arbitration, whether ad hoc or institutional arbitration is preferred mode for arbitration, especially when you take into consideration, what we just spoke about, the ease in enforceability of awards. What is more preferred in Malaysia?
Let me share this screen with you, then you can see what I mean. See, in Malaysia, we have gone through a lot of amendments as far as the acts are concerned. Prior to 2005, we have the 2005 Arbitration Act. And now we have this prior to the 2005, we have an earlier Arbitration Act 1952. And thereafter, we have this Arbitration Act 2005. And the importance of this 2005 Act is that it limits the court's jurisdiction insofar as arbitration proceedings are concerned by limiting it only to questions of law under sections 42. Now, that has been further amended in 2011 by saying that the provisions for stay are further limited unless it is null and void. Now, the most recent amendment is the 2018 amendment, which says that you actually remove section 42 and 43. And the effect of this is that unless and until the award is actually null and void and cannot be recognized, then an arbitration award would be recognized by the courts. which means that there is a greater emphasis now. Courts are less willing to challenge an arbitration award unless it is manifestly wrong or on grounds of jurisdiction or other very substantial grounds. And I just want to show one other case, which is the recent federal court case of Pancharan Prima Sendirian Berhad versus Ishwar Bina Sendirian Berhad 2021, delivered in 27 of August 2020, whereby the arbitrator concerned was able to give a 10 to 15% risk profit in the Malaysian construction industry. Now, this is something which is quite unusual because by and large, profit assessments are very, very difficult to get. So that if your particular arbitrator does not give it to you with a 10 to 15% profit gain, then if you are going to have to prove it in a court of law, you will find that it is very difficult. So this is where the choice of the arbitrator becomes very important. That's all I want to say. And so far as the slides are concerned, but sorry, Ish, can you repeat that question again? I have got
Yes,
lost at that.
no difficulty. The question which I had in mind was, when you talk about enforceability of an award in Malaysia, would a person choose ad hoc arbitration or would they choose institutional arbitration? Which is more preferred in terms of
Okay.
enforceability of the final award?
Okay. Now, when it comes to enforcement, assuming that you have gone past all those problems that Karen was talking about Karen was talking about earlier about the appointment of the arbitrator and so on and so forth. Assuming you've gone through all that and you have also avoided all those problems about procedure and evidence and the way in which the arbitration is actually conducted, with and without the presence of counsel and so on. Then when it comes to enforcement, as I said earlier, normally the Malaysian courts after 2018, they will be quite in favor of the arbitrator unless you can show that he has gone out of his jurisdiction. Now, the most recent case that I had actually shared with you shows that the arbitrator, whatever his award is, unless you can show that he's biased, there's grounds of fraud or excess of jurisdiction, you have to accept his award and it is enforceable. So that places a lot of confidence insofar as the arbitrator is concerned, that if his award is given, then you are quite sure that unless there's a major problem, that award would stand and that you will get your money at the end of the day. Of course, if it is in another jurisdiction, then you would have other problems whereby you have to make sure that you comply with the New York Convention. We will see other slides later whereby you see that when it comes to actually choices of a venue to enforce, then you have to see whether or not your initial decision to proceed with ad hoc arbitration instead of institutional arbitration, that would come back to haunt you, because if your initial arbitration did not comply with certain rules as to the seat of arbitration and so on, then you would have problems when it comes to enforcement later.
All right, Roland. It's a very interesting take, Roland. Well, no webinar in these days is complete without discussing the issue of what the pandemic has to do with the issue in hand. So, Karen, I would like to get back to you and ask you, what do you think, the ad hoc arbitration was more preferable mechanism during the pandemic, or in such situations an institutional arbitration is more safer, more conducive to the environment?
Can I just, yes, I'll deal with that, but can I just round off what Roland was saying and what Anand was saying? First of all, I think in terms of enforcement under the New York Convention, the ground of enforcement, the article dealing with enforcement is Article 3, but Article 5, which Anand mentioned and Roland mentioned not in name but in substance, it is the grounds for resisting enforcement. And most jurisdictions, whether they're dealing with domestic or arbitration awards, have really taken their cue from the New York Convention and introduced grounds for resisting enforcement of awards similar or the same as those in the New York Convention. But you also have to distinguish when you're talking about enforcement between annulment, which you would do in the seat of the arbitration, and enforcement, which would be wherever the losing party has got assets around the world. So there are those key distinctions, but the things that go to enforcement are really the clarity of the arbitration agreement, which we've discussed. So if you're going to have ad hoc, make sure your agreement is clear. Whether rules have been adopted, and Anand was talking about rules and adoption of rules, which is really important. What those rules say, and how that impacts on the place of enforcement when you're trying to enforce your award. And last, but by no means least, the quality of the arbitration tribunal, and then the quality of the award itself, which really brings in all of the things we've been discussing. And those key features are equally important in ad hoc and in institutional arbitration. So going into the post-pandemic question, what do I think the pandemic will impact, how it will impact the evolution of arbitration? Well, I think I've been usurped by Tan Sri Fung, really, because he's been talking about all these things. And he said at the very end of his speech, effectively, look, we've made all of these changes during the pandemic, and frankly, there's no way back. And I completely agree with what he's saying. In different parts of the world, you have to manage the resources that are available wherever you're arbitrating or you're dealing with your disputes. But essentially, it will never be the same again. And we will, and I've seen already, looking at other arbitral institutions, I mean, ADR is coming, ADR is coming at all these things afresh, so everything is right up to the minute. And I have to say, with Professor Raju, he's never been anything less than up to the minute. But all of the processes being introduced by AI ADR, they're right bang up to date, up to the minute. Others are changing their processes. There's been lots of arguments whether actually, if you're having a virtual hearing, that is in accordance with the arbitration agreement of the parties, because some agreements have been not well defined. So I think we'll see arbitration agreements changing to make sure that all these new processes are acceptable. So at the end of the day, you are going to have an arbitration process which can be relied upon and an award that can be enforced, because that is what all of this is about. At the end of the day, you want an arbitration award that you can enforce. So you have to make sure that the structure of the arbitration and the conduct of the arbitration going forward is able to produce that result. And the pandemic caused us all to have to change the way we work and the way we present evidence in arbitration, the way we deal with experts in arbitration. There were so many things that had to be adapted so that arbitrations and dispute resolution could continue. And I think that may increase the popularity of ad hoc arbitration over institutional arbitration. Whereas before the pandemic, the costs issue would be less of an issue. I think post-pandemic, it will be very much of an issue. And so a lot of medium and small enterprises will be looking to see if they need a binding, instantly binding and enforceable dispute resolution mechanism. They'll be looking to see if they can find an ad hoc procedure, or to carve out an ad hoc procedure can give them that. And that, of course, is the flexibility of ad hoc arbitration, although I would expect that the institutions will be racing along the road now to produce all kinds of different flexible procedures that actually you can then bolt on sector-specific rules to make them work. I mean, I wouldn't be surprised if we see something soon from a number of them in that respect, because all the institutions will readily appreciate that parties don't have the resources to fund expensive administered arbitration. I think we'll see lots of changes, but as Tan Sri Fung said, and I think he said it really eloquently, you know, that we've all got to get up to speed, we've all got to get properly trained. He did suggest that it should be a requirement of arbitrator qualification that we all become techie savvy. I have to say, if it'd been a requirement of mine at the time, I never would have passed, but we are all having to learn and we're all having to adapt really quickly. So yeah, it's never going to be the same.
Thank you, Karen. Excellent thoughts, Karen, and excellent views from Roland and Anand as well. I have many more questions, but we're running short on time because we have the second session as well. So I would like to conclude this session with some of my thoughts as well. Obviously, all three of you all have helped me formulate this. And I just like to say that ad hoc arbitrations are considered as flexible and enables parties to decide upon their own dispute resolution procedures. But such arbitrations are hit by a procrastinated manner where such proceedings are dragged on and parties end up paying exorbitant fees. From what we've seen about the AI-ADR rules, it's a process in the right direction to remove these difficulties and make ad hoc arbitrations more amenable to parties which prefer the mechanism. And it's a long way to go. We can never rule out one of the methods, whether it's ad hoc or whether it's institutional. Both have their advantages and disadvantages. So I think that's my understanding from and intake from this webinar. Well, with this, we can come to a conclusion of this session, and I would like to thank Karen, Roland, and Anand for sharing their wonderful experience and making it a fruitful session for everybody. Sorry we could not take a lot of questions because we're running short on time, but I hope you can get in touch with any one of us on our LinkedIn or emails, and we would be happy to answer those questions for the attendees. Thank you very much, and cheers and stay safe.
Thank you, Ish.
Thank you, Ish. Thank you, everybody.
Thank you, Ish. Thank you, Karen. Thank you, Anand.
Thank you, Roland.
I hope everyone found the panel discussion to be conducive. Once again, on behalf of the AI-ADR, we would like to thank Mr. Ish, Ms. Karen, Mr. Roland, and Mr. Anand for your willingness to share your time despite your busy schedules and different time zones. Our second panel discussion of the day will be centered on the quintessence of arbitration in the Belt and Road Initiative, adopting foreign practices of arbitration. Let us welcome our moderator for the second panel discussion, Dr. Srikant Parthasarathy. He is a fellow of the Asian Institute of Alternative Dispute Resolution. Dr. Srikant is a legal professional and a chartered accountant and a PhD in finance from the United States. Dr. Srikant is also a mentor at the Ministry of Information Technology. He comes with more than a decade of experience in the legal and investment banking industry with Citibank. He later moved on to become the head of process and policies at Daimler. He is currently the managing partner at Chakra Ventures Partners, LLP, a boutique legal private equity firm that focuses on arbitration and legal. He is also a professor of finance at IIM's SP Giant India and global campuses. He sits in the panel of arbitrators at various globally renowned institutions, including AIAC, JKIAC, ADGM, and more. Without further ado, I shall pass the forum to Dr. Srikant.
Thank you very much, Adrian. It was such a lovely introduction. I'm very conscious of the time that we have. I'm made to understand that we have about an hour to discuss such an interesting issue that we have in front of us. However, without further ado, let me welcome the panelists, the esteemed panelists what a wonderful panel that has been put together, and it is my privilege to actually welcome each one of you. Let me welcome Dr. Dugal, Kabir Dugal, who is joining us from a very unholy time zone, and he has been so gracious about it. Mr. Lai Zixing, and it is a pleasure to have you, sir. And Mr. Yao Zinxia, it is a pleasure to have you as well. And last but far from being the least, Mr. Martin Pulain. I shall move to your introductions towards the later part because we have such an interesting topic ahead of us that I'm so inclined to hear your views insofar as the topics are concerned. Uh, the Belt and Road Initiative is one of the most, I would say, contested topics without naming it as a contradict. I mean, contesting or a more a debatable issue. But we have 67 countries which have signed up to it, and we have as early as May, we have China Plus policy, which is going on. So without going into the ASEAN aspect or the China aspect or the Asian aspect to it, I would like to focus on the ad hoc, which is the theme that we have right now, and the BRI itself, and what kind of a solution does it provide, or what kind of mechanism does it provide for the ad hoc arbitration as such. So with that comes my first question to the panel, and I would request Mr. Zixing to possibly start off this heated debate, and with the conscious effort of keeping the time, requesting you to be as telegraphic as possible. So why is arbitration an appropriate dispute resolution forum or an appropriate dispute resolution mechanism in the Belt and Road Initiative? You're muted, sir. Mr. Zixing, you're muted, sir.
Okay. Can you hear me? Forgot to
Yes.
unmute. Okay. Thanks, Dr. Srikanth. In view of the little time that each panelist has, so I have to go it fast. Now, for the Belt and Road Initiative projects, typically the contracting party are either the local government in the host country or the local contractor contracting with foreign contractor. So there are two types of contract typically in the this kind of BRI projects. One is the host country government forming a contract with the foreign contractor, or it can be a local statutory body. The other type of contract may be a local contractor, subcontract to a foreign contractor. So there are two types of contract here. For the first type of contract between the local government or the statutory body and the foreign contractor, typically they use a standard form of contract. For example, in Malaysia, the Malaysian government will use the PWD form of contract, whereby the is very common for other country as well, whereby standard arbitration clause is already been incorporated into the contract. So there is no issue of ad hoc arbitration because the arbitration clause has already been incorporated in the contract by itself. But the problem may occur between a local contractor trying to subcontract to a foreign contractor, whereby the parties are free to agree on the terms of the contract. So therefore, the arbitration clause may not be a standard clause in the contract. And where the party, if they have dispute in the course of the construction, they may adopt, to resolve the dispute, they may adopt ad hoc arbitration.
True.
Now, why we prefer the arbitration and we think that is appropriate? Now, the first thing is because there is a differences between a local contractor and a foreign contractor in terms of cultures and the way of working and especially in terms of the way of handling the project. Therefore, the dispute is not uncommon, especially between a local contractor and a foreign contractor. Now, if the party do not adopt any arbitration clause in the contract or without any ad hoc arbitration, then the party had to resolve the dispute to the local legal system, local court. Now, there is a problem here that the foreign contractor, they feel uncomfortable and felt that it may be too risky to adapt to the host country legal rules. We may not be right to say that there may be a kangaroo court, but the fear is always there that you feel uncomfortable to fight for a case in a country which is not familiar to you. Of course, there are related issues that you may pop up in your mind, whether judges are impartial or not, whether are you able to enforce the court order easily or not? Are there interference from the executive in the enforcement of the court order? Now, how about interim order? Is the government, the legal system favor the enforcement of the interim orders, like injunctions or discovery order? So by having the ad hoc arbitration, if there is no arbitration clause, then the party may be able to have the option to decide on a lot of issues that may be able to resolve that dispute. Now, one of the important issue for the party to get agreed, number one, is the governing law. So with the ad hoc arbitration, then the party can agree on the governing law. But it's a standard practice that it is preferably to adopt a neutral country governing law. For example, if the contract is between the Chinese contractor and a contractor in Malaysia, so if both parties not feel comfortable with the governing law, so we may adopt a governing law as a UK governing law or Singapore governing law, a neutral country. Similarly, the arbitration agreement, the governing law, you may want to adopt governing law from the neutral country as well. And the other important thing for ad hoc arbitration is the party had the option to choose the seat. The seat is important because that would talk about the enforcement of the award later, and of course the governing the procedure in the arbitration. Therefore, it is preferably that the party can adopt the seat in the neutral country. So for project in let's say in Malaysia, if the contractor is a Chinese contractor, if a local contractor, Malaysia contractor, so we may opt to choose a seat to be in Singapore or in Hong Kong, a neutral venue where no party will feel uncomfortable with, right? And the other important is the appointment of the arbitrator, right? So you feel uncomfortable that I appoint arbitrator from my country. Likewise, the other party will also feel uncomfortable if you choose an arbitrator from your country. So with the ad hoc arbitration, this can be decided, agreed by the party to choose an arbitrator or three arbitrators from different countries, not from the host country.
True.
Okay.
So I have a follow up for the other panelists on the point issue or the point raised by Mr. Zijing, which is the arbitral clauses flexible enough to allow a different seat, a different procedure, or a different set of rules or a setting altogether in the limited context of BRI? That is one side of the issue. And second part of the issue, are the rules, is the BRI flexible enough to have ad hoc arbitration? And where do we see ad hoc arbitration blooming in the BRI? Of course, you may also answer the question which I posed to Mr. Zijing. Anyone in the panel may take up this particular question.
Perhaps I can perhaps say something, Srinath. I'm grateful for the follow-up question. Obviously, as far as an arbitration clause is concerned, then yes, of course, there's a lot of opportunity for parties to shape their own procedure, be that ultimately institutional or ad hoc. But I think looking at your follow-up questions and the initial question you posed, there's, I think, the issue of whether, in fact, as the arbitration community, we are still able to demonstrate that arbitration is, in fact, the most appropriate dispute resolution method for Belt and Road disputes. And I think there are real challenges, and we can't, frankly, rest on our laurels. We know, don't we, that, for instance, the international commercial courts that have grown up, many of them modeled on the London Commercial Court, are seen by many as competitors. Perhaps we should see them as being compatriots or complementary. But I think nevertheless, there's clearly competition there. I think if we look specifically at the China International Commercial Court, of course there are concerns there around scope for foreign representation, for instance, foreign lawyers. Nevertheless, I think it's put down a marker. It's marketed itself, hasn't it, to some extent, as a sort of one-stop shop: mediation, arbitration, litigation. It's demonstrated perhaps an innovation. And I think that arbitrators and the arbitration community really need to step up to the plate and respond to that. I certainly find that, and I'm sure many colleagues do, that clients do have misgivings around efficiency, both of time and cost, when it comes to arbitration. Cost not in terms of arbitrators' fees, institutional fees, venue fees, etc., but actually the overall cost of proceedings, because we know that some representatives will treat the arbitration process as litigation in disguise, and costs will rocket. We know that. So I think we need to look at case management, for instance. I think sometimes arbitrators are reluctant to effectively case manage in a way that, for instance, judges in courts will, certainly commercial courts will. So I think we need to take that on board. And I think, in fact, in that regard, the AI ADR rules that obviously are being launched today are really to be welcomed, because they, of course, address fees, arbitrators' fees and administrative fees. They address, for instance, the appointment procedure, all the issues that in ad hoc arbitrations can sometimes derail or lengthen the process. I think that's to be welcomed. I think also we need to look at perhaps some issues that we're often uncomfortable with. We always set great store by the privacy of arbitration proceedings. Some would say the confidentiality, although as we heard in the first panel, confidentiality is not absolute, and it is very much honoured more in the breach than the observance. Nevertheless, parties sometimes see a superficial attraction to confidentiality. As against that, of course, international commercial courts will provide, and to some extent are providing, a perhaps perception of more consistent jurisprudence. Parties know sort of what they're going to get. They know what perhaps decisions on key points of law are likely to be. There's not always that predictability or certainty with the arbitral procedure. Now, of course, one doesn't want to necessarily, or parties don't want to throw open the doors to publicity. I think at the same time, there needs to be some form of greater transparency so that parties feel confident in knowing what character, what demeanor an arbitral tribunal is likely to demonstrate. It is, in reality, difficult sometimes for parties even to know the quality of perhaps the arbitrators they have in mind for appointment. So I think there are those issues. Of course, arbitration for Belt and Road cases has the attraction of the finality of the award, obviously subject to challenge, limited challenge, and also, of course, global enforcement. I think one has to recognize that. But I think we really do have to try to market ourselves, perhaps in a way we haven't necessarily marketed ourselves before. Issues such as joinder of third parties, for instance, that can present a real challenge in arbitration, not so, or not necessarily so, in litigation. So I think those are the issues on court versus arbitration. And then as we're discussing ad hoc arbitration, of course, we need to bear in mind, I think, that over the last few years, the arbitral institutions in the region, particularly Hong Kong and Singapore, have gone out of their way to market themselves as the go-to venues for Belt and Road disputes. And I think, again, the new rules that we've seen launched by the ADR are perhaps redressing the balance for ad hoc arbitrations, and perhaps giving parties more confidence to embark on an ad hoc procedure. So I think, Srinath, I would just say that in response to your question.
Thank you, Martin. Dr. Dugal, what are I'm interested to hear your views. Of course, I'm interested to hear Mrs. Enchue's views as well. But let me jump on to the man from New York, man. So what are your views?
Sure, thank you. And please, you should feel free to call me Kabir. Let me just start off by highlighting from my perspective, what do I see as being some key characteristics of the BRI? And I think some things that stand out for me are the following. We're talking largely about big, complicated infrastructure disputes, infrastructure matters leading to disputes. So that's one component. You're talking about contracts which would, for practical purposes, be long-term, right? Infrastructure tends to take time. That's the second thing. The third feature that I see is that these contractual arrangements can be complicated. You can have a variety of different parties playing different roles, right? Somebody supplying, somebody constructing, somebody doing, it's a complex web of different players. And we're often talking about matters that are heavily regulated. Now, if we look at these features, it does seem to me that arbitration tends to be the preferred choice. So, just drawing on the excellent comments we just heard, you have the option of mediation. That's something to think about. The Singapore Convention has strengthened international mediation. China, to the best of my knowledge, unless something changed radically in the last month or so, has signed but not ratified the Singapore Convention. So we have a little bit of a question mark there. We heard Martin just speak about the commercial courts in China. This is the one-stop shop mechanism for dispute resolution. China, to give it a lot of credit, has tried to come up with some innovative ideas, right? You can enforce judgments from Hong Kong directly in China now. There's been this arrangement put in place. There is also a mechanism that, interim measures is available for Hong Kong seated arbitration from Chinese courts. There are improvements, but, the meta question remains whether you want to go to courts or whether you would prefer to go to an independent body that can be enforced, outside the state. I still think that would be an appealing idea. In the interest of time, I'll just make a very quick in and out comment on ad hoc arbitration. If we're going to go by completely unscientific but highly persuasive surveys that are done, Asian parties still tend to prefer ad hoc arbitration. That is the reality we find ourselves in, for better or worse. Chinese law is not fully explicit on whether domestic ad hoc arbitration is valid. I'm made to understand that under Chinese law, it has to be institutional arbitration. Domestic ad hoc arbitration is invalid. We are likely in the BRI disputes going to be in foreign ad hoc arbitrations. If they're taking place in China, we're still probably in a gray area, but likely it seems to be okay. But arbitration is sufficiently flexible, subject again to the points that Martin reminded us to think about. It's sufficiently flexible for us to be able to accommodate some of the problems that we may be talking about. In the interest, I can go on, but in the interest of time, I'll stop here and pass the mic back to you.
Thank you, Kabir. Mr. Zinxia, if I may call you Yao, with your permission.
Okay. Can you hear me?
Yes,
okay.
Now yes.
Yeah. Okay.
Your views. We've been discussing I wouldn't say a polarized view, but we have a view in terms of, or some kind of I would say apprehension in terms of the seed being China, and the institutional rules which are being adopted from outside. So ad hoc arbitrators, which Kabir very rightly pointed out to, international. I wouldn't call them international surveys, but we arbitrators, we are a close group. We know exactly where the ad hoc arbitration lies. Considering the fact that ad hoc arbitration exists and it is not going to go away, but of course, they have to adopt certain rules. But again, the question of seat arises in China. What are your? I mean, we wouldn't want a discussion on the seat versus the rules debate. But insofar as the question of choice of rules is concerned, or the choice of the institutional rules is concerned, what are your views in terms of the BRI? And is the BRI flexible enough to adopt a foreign, I would say, an internationally accepted rule, like the AIAC rule, or like the rules which are brought out by AIDR? So where do you find the flexibility in the BRI? And if so, where do you see ad hoc arbitrators using that flexibility? I'm sorry, I'm loading you with questions. Let me put it a straight one. Is there a flexibility in the BRI rules at all?
Thank you. Actually, I want to. I have a paper which I have prepared. So I want to introduce that first. Is that okay? Is that okay?
Of course. Very well.
Okay, I want to share my PPT.
Which unfortunately, oh yes, thank you.
Greetings, great honor to join this forum. That I have prepared this topic, and delight to share the child practice and experience of Guangzhou Arbitration commissioned under the BEL and BRI. The BRI, a state-level process proposed by China, has received active response from many countries and regions worldwide. Since countries and regions along the BRI route and in different economic development stage and have other law systems and investment environment, economic and trade friction between different leading players is only nature that calls for the operation of dispute resolution scheme. Arbitral award made and issued by arbitral bodies based on the New York Convention can be recognized and enforced in more than 160 countries. Therefore, arbitration is naturally positioned to resolve commercial disputes that involve foreign elements. Thus, it has extraordinary development potential for resolving disputes in advance the BRI. Concerning following elements, the phenomenon of 390% should not be ignored in the arbitrations. First, more than 90% of the foreign-related commercial contracts signed by Chinese enterprise are choosing international commercial arbitration to resolve dispute. Second, 90% of the dispute resolution costs of contract favoring international commercial arbitration choose to refer disputes to overseas arbitral bodies. Third, more than 90% of the Chinese enterprise fail the international commercial arbitral when dispute arise. To respond, a threat of change brought about by the BRI invest in advance and provide a solid guarantee for the Chinese enterprise to go global. Guangzhou Arbitration Commission, which is said GZAC, which is among the earlier best of arbitral bodies in China, has always prioritized the development of international commercial arbitration service. It has made various attempts and efforts in recent years, including the following practice. GZAC has been committed to explore the Internet Plus arbitration scheme to bring more accessible arbitration service to the countries and regions along BRI. In 2012, GZAC set up the Nansha International Arbitration Center to take charge of international commercial arbitration cases. The center can conduct arbitration following the three court model applied in the mainland, Hong Kong, and Macau. A distance court hearing has become a reality by relying on internet technology, and GZAC can include BI-related commercial disputes in the resolution scheme in the Great Bay Area. The Guangzhou model, which integrates the synchronized operations of the three court models in the mainland, Hong Kong, and Macau, with distance calls for international commercial arbitrations, has taken shape. On November 20, 2019, Nansha International Arbitration Centers conduct the world's first distance arbitral court hearing by relying on the advanced 5G video technology. The Chinese and Cambodian parties involved in the case talk to each other face-to-face at a video meeting arranged by tribunals and research a settlement agreement at last. The case created a precedent for conducting international commercial arbitration through remote connections. On January 15, 2020, GZAC successfully attribute a dispute over an international sales conduct between Indonesian enterprise and Chinese enterprise. In this case, GZAC connect each part and attribute arbitrators in 3 different cities. The parties highly appreciate the efficiency, convenience, and economy of the arbitration. Accordingly, they accept and enforce the arbitrate award happily. To further extend the leverage of the internet-based arbitration, GZAC has formulated the world's first standards for interest-based arbitration. Underpinning by the technical support from the China Academy of Arbitration Law. At present, more than 100 arbitral bodies in the mainland of China and more than 20 overseas arbitral bodies has signed to accept and agree to extend the application of the Guangzhou Standard. Widespread cooperation has been established, which involves major arbitral bodies in Hong Kong, Macau, and Taiwan, and countries and regions around the island, including the Singapore Chambers of Maritime Arbitration and the Korean Commercial Arbitration Board. The new attempt respects the interval of GZAC is responded to the Belt and Road Initiative and is commercial to building a global communicate of law for arbitration to extend the application of arbitration across world in the resolution dispute. Surely, GZAC will keep on moving to advance the Belt and Road Initiative. GZAC will continue to get involved in extend exchange and sharing activities and keep close ties with the commercial chambers and trade associates of the countries around the road and the embassies and consulate stations in China. In addition, GZAC will hold conference under the BRI theme and invite relevant professions from the countries around the road and Great Bay Area. Furthermore, countries should work together to cooperate in law to improve arbitral service and promote international commercial arbitration. It's my hope that based on this virtual face-to-face relationship established through this conference, in the future, we can share more experience, further strengthen cooperations, and achieve our shared object. Thank you very much. And I'm very sorry, and I have to apologize that due to other conference that couldn't be rescheduled, I might not join the following sections, but if you are interested in any content of my speech, or you need to further understanding of my speech or understanding of GZAC or any further discussions, please do not hesitate to contact me. Thank you. Thank you very much.
Thank you. I mean, we were not aware of the collaborative style that the institutional arbitrations have to take is quite explicit by the way that you presented, Mr. Zinshia. It was really exciting to actually go through your small presentation. To understand where exactly is GIAC and where exactly is NIAC and so on and so forth. It is quite. I mean, it would be interesting to compare the rules between the arbitral institutions to see if the rules are international and they are inclusive and so on and so forth. That brings me to with a profound gratitude to Mr. Yao. May I turn to the other panelists with that particular note? Yao touched upon a very interesting topic. We have institutions which have got arbitral rules. Martin, I'm directing this question to you. With so many institutions having so many universal or best practices rules, so to speak, and Ansutral is honestly, let's face it, it's about 70 years old. Of course, there is a working group and so on and so forth. But do you see that there is a level of standardization that has happened in the arbitral institutions so that ad hoc arbitrators could possibly take in the most standardized rules which could save them from, for example, in my jurisdiction, at least where I sit from, usually I have a flag of India and behind me, but unfortunately it seems to be missing today. It was there in the last instance that we met. But in India, we have an issue of the standardization and the applicability of rules or the reciprocal arrangements of the enforcement of the awards to be missing. So that is one of the things. So you can entertain a plea in a lower court and so on and so forth. So one of the issues that we arbitrators in India feel is that what a judgment, I'm sorry, it naturally comes out as a judgment to me because I come from a common law jurisdiction. What award that we pass as an arbitrator will be challenged in what particular forum. So Martin, without further ado, let me ask you straight. Is there some kind of standardization that we could do in arbitral rules, which could be easily adopted by ad hoc arbitrators and which could serve as a template to save them or to mitigate from all the risks that may arise from any risk? I mean, we're not immune from litigation against us, but any litigation that may arise, and because ad hoc arbitration primarily seems to be worried about the litigation on a personal front that arises on the arbitrator. So without taking too much time, Martin, the floor is all yours.
Thanks so much, and thanks very much for the question. It is an interesting one, isn't it? Because certainly institutional rules have undergone a number of refinements over the years, particularly recent years, and have adapted to new and emerging demands, have refined the process. And as you said, the UNCITRAL rules, although of course we've had a few incarnations of them, in some respects have been perhaps left a little behind. And I think there's no doubt that two issues arise. First of all, I think SMEs sometimes feel that the ad hoc process is not necessarily for them, or that they've been neglected, that the SME with a reasonable size but not a particularly large claim may feel that an ad hoc arbitration under UNCITRAL rules won't shape proceedings in the way it would like. Similarly, I think there's a feeling among some clients that I certainly come across, although I think I should say immediately there's no evidence for this. There's certainly a feeling that having an institutional arbitration under certain established arbitral institutions will lend more credence, more credibility, will better equip one to enforce an award. Now, as I've said, there's no evidence for that, but I think there is sometimes that feeling. So what can we pull out from those institutional refinements, those institutional rules, to incorporate into the ad hoc process? I think going back to what I said earlier around case management, I always like the idea of terms of reference. We know that in the ICC rules, there's the requirement for terms of reference to be set out. And of course, the arbitral tribunal, in conjunction with the parties, will address that. I think there's no doubt that focuses the mind, that enables parties and the tribunal to identify issues that are live, to focus on those, gives shape to the proceedings. And I do think that's the ongoing challenge for all of us. So I think certainly having explicit requirement for terms of reference to be agreed, that's something that can and should be incorporated into an ad hoc procedure. And going back to the SMEs, the idea of an expedited process. If we look at the arbitral institutions within the region, we see that expedited processes have been introduced for lower value claims. That's clearly going to be attractive, along with summary processes, both the ability to have an early determination of either facts or law where the argument will be there's no merit to those particular issues, those particular facts, that particular application or interpretation of law. I think early determination is an issue, along with actually having a process for summary dismissal. So of course, if we look at the SIAC rules, we see a summary dismissal procedure there. That's something that parties do want, or in my experience, very often do want to see, because of course, they're often familiar with that in litigation. And we spoke earlier, didn't we, around the issue of confidentiality, the fact that it's not all it seems, it's not absolute. I think for those parties that do want to try and ensure confidentiality, although that may not always be possible depending on the jurisdiction where the arbitration's seated, some of the institutional rules containing the express provisions, express rules as to confidentiality can again be brought on board. So I think those are key issues. And one of the problems with the UNCITRAL rules, it seems to me, and of course this is something that's reflected in the model law as well, is if one's got a 3-person tribunal and there's no majority on a matter of substance as opposed to a matter of procedure, we know, of course, under the UNCITRAL rules, there's not provision for the presiding arbitrator to then make the decision. He or she can on matters of procedure, but not on matters of substance. And if one looks in contrast at the institutional rules, particularly those in their latest incarnation, we see that that's been addressed, and it's given the presiding arbitrator that ability. So again, something else which will from time to time arise in practice and will sometimes then cause difficulties. And I think the final point, I suppose, is around model clauses. Arbitral institutions have been diligent in shaping model clauses, and of course, encouragingly, we see in the AI ADR rules the model clause. I think those institutions that have model clauses that allow parties or encourage parties to adopt the more rather than less approach and build in as much into the arbitration clause as they can before a dispute arises is perhaps a lesson to all of us. I think it was Karen in the earlier session who made the point that once a dispute arises, parties will tend, almost as a matter of principle, not to agree on anything. All the more reason to be preemptive, get as much agreed in the arbitration clause that you can. So I think that's another lesson for the ad hoc procedure and for ad hoc arbitrations to take from the institutions, standardization around the ability to put as much, without being unduly prescriptive. I recognize one can't cater for all eventualities, but being as preemptive as we can. Because I think, again, if we're doing some soul searching, we, certainly those of us as lawyers who are representing, advising clients when it comes to the drafting of arbitration clauses, I think sometimes we're not as forward-thinking, we're not as proactive and preemptive as perhaps we should be, and as perhaps we should encourage the client to be. So that's I think what I'd like to know. That's I think what I'd like to say on that. So thanks so much for that question.
If I would be unkind to Mr. Zixing if I didn't hear his views. Mr. Zixing, I'm eager to hear your views in this particular matter. And then Kabir, sorry, I'll come to you later.
Of course, it's nice to have standard international arbitration rules, and that is supposed to be played by the role is to be played by the UNCITRAL rules. But like Martin has brought up, there are some weaknesses in the rule itself. They need to be amended further. But then again, as far as I know, for example, in Malaysia, the AIAC rule actually lie right on the UNCITRAL rules. Same thing for another local institution. There is Institution Engineers Malaysia. The arbitration rule also right on UNCITRAL rule with modification. So we have adopted the UNCITRAL rule with modification. So that in that sense, we had used the UNCITRAL rule as international arbitration rules. But actually, I wanted to add on two things that Martin brought up earlier. on the earlier issue. One of the biggest advantage is for the arbitration, whether ad hoc or institutional or contractual, is the enforcement of the award, especially when two parties are from two different countries. So for BRI projects, one is local contractor, the other one is a foreign contractor. So you can imagine if the local contractor wins in the arbitration and he has an award in their favor, can they enforce it on the foreign contractor who just came into the country, set up a company to carry out the project? So there's no asset at all, except a company to register for the sake of carry out the project. So there's nothing much you can enforce it and to enforce it and to realize your award. So the international corporate enforcement is a greatest advantage, because then you can go over to the country of the contractor and to seize their assets. And that I personally had a lot of experience on this field, right? Especially when I'm advising a local contractor tied up with a foreign contractor. Lately, I've been advising. So the party asking me to advise them what is the advantages if I put an arbitration clause in view of the high arbitration cost, COST cost, right? So I told them that the biggest advantage is the enforcement of the award globally. But then again, it depends on which party you're looking at. If you are a local contractor, all right, so it might be better for you to do it without arbitration clause. All right, so sorry, if you're a local contractor, it's better to have arbitration clause, just in case if you win in the arbitration later, you can enforce in the country of that contractor. All right, but if you're a foreign contractor, it's better to not to have an arbitration clause, because in case you lose in the arbitration, they cannot enforce it in your country. So it really depends on which party you are acting for. And because the problem is ad hoc arbitration is both parties had to agree. So that is one of the biggest hurdle the party had to cross before you. I can see that it's not easy to get the ad hoc arbitration to be agreed between a local contractor and a foreign contractor. And that I had that problem with one of my own personal experience.
True. Which is where the mediation possibly comes in, to get that agreement in place. Without delving into that, Kabir, your views insofar as this is concerned, is there a standardization that we could apply? I mean, are the proliferation of institutions and the proliferation of good institutions, the top 10 is getting crowded right now. So what are your views insofar as the institutional rules that an ad hoc arbitrator could approach?
Sure. I'll try to make 3 points and I'll make them in the interest of time relatively quickly. You raised such an interesting point when we talk of harmonization, right? Because I think at a meta level, this is the tension we have, right? You want arbitration to be flexible, to be something we can tailor, but at the same time, you want it to be a process that is acceptable across parties and can be harmonized. And I think these two views, right, let every party do what they want versus having the need to have some familiarity across jurisdictions is where we see the tension. So that's the first point. The next 2 points I would make, to the extent we want to have an harmonized process, the UNCITRAL model law, which is intended to give inspiration to states, that does give us a framework that could be adopted to ad hoc arbitration. Now, you were talking about time, and the UNCITRAL model law is itself quite old. It was amended in 2006. That's also quite old, so I do acknowledge that. But you at least have a framework that could be adopted. The final point, I think this is just to echo what Martin and Liaise spoke about, In ad hoc arbitration, I think the most critical point also is for the parties in the clause to try and address as much as they can, right? The more you yourself agree to a framework, there's something laid out, very often these clauses, the proverbial midnight clauses, are quite lean, quite cut, copy, paste, and, often they don't make a lot of sense. So a little bit of thoughtfulness in the clause itself can spell out some of the processes that can make things easy. In the interest of time, I'm enjoying this discussion, but I'll stop here and pass it back to you.
As a final question and a 30-second, if I may request the panelists for a 30-second answer. So tying back to what Kabir just said, we have an issue of the ancestral model, and then tying back to what Mr. Zishing said with respect to enforcement. Does this make it advantageous or disadvantageous for the BRI? I mean, how does it tie back to the BRI? What are your views? It could be a binary, yes or no, or it could be the lawyery answer or the counsel-y answer of it depends. But I would welcome your thoughts.
Do you want us to start in any particular order, or how would you like us to do it?
It's a free-floating question. Anyone can pick it up.
Okay, maybe I'll start off. A quick one. I definitely think there are a lot more advantages than disadvantages for the arbitration especially in international projects. But one of the biggest hurdle that my own personal experience is cost. The cost arbitration is going up, and it's going sharply. Right? That's the reason why a lot of legal counsel are moving away from the court litigation to the arbitration now, because the fees are high and the arbitrator's fee is not cheap. Whereas you go to court, you do have to pay the fee to the judges. So, and that's one of the biggest problem I have to convince my client that to adopt the arbitration clause in their contract. So they always ask me, how much does it cost if I really go into arbitration? I say, no, it can really cost you a fortune. It's not cheap. And my personal experience is one of the dispute we have, only about 1/1,000,000, 1.2, I think, dispute. The cost of arbitration eventually came out to about, for two parties add up, 200,000. So it's about 20%, 20%. So sometimes it really gives you a second thought. Are we moving in the wrong direction or not? Or everyone is making too much money from the suffering of the parties. This is the comment made by my client. You say you lawyers are making money from our suffering. So while I say, well, that's how the market goes, but I cannot change it anyway. But I think that is a problem that we had to give a serious thought if we really want to make arbitration a success eventually. And we must think less of the monetary gain, both as a counsel and as arbitrator. I have one case also, arbitrator is taking advantage, asking us a very high fee, not a standard fee, higher than a standard fee. So my client asked me, so what to do now? Want to agree or don't want to agree? So if you don't agree, you're afraid you antagonize the arbitrator. So I say, I cannot advise you, but you just have to accept it. I think that is no choice.
That's a discussion that the arbitrator should have with the philosopher and the neuroscientist. Martin, would you have some thoughts? Telegraphic.
Yes, I'd agree that it is advantageous. Of course, our arbitration is, but just to echo exactly what's been said, it needs to keep current. It needs to keep relevant. Also, we need to be joined up. So if it's a question of encouraging mediation, if it's a question of encouraging multi-tier or hybrid clauses to work effectively, we have to take that on board. And as I was saying at the outset, looking perhaps to work in a complementary way with the international commercial courts that are out there. But certainly, we've got to remember that we all talk about arbitration being the party's own process. I think as lawyers and as representatives and as arbitrators, we always need to have that in mind and not lose sight of that.
Kabir?
Yeah, we must remember that.
Wanted a 30-second answer. I'm going to agree with my prior two panelists. There are more advantages, but we need to revert to what arbitration was intended to be: an efficient, cost-sensitive, flexible process. I see Adrian's here, so I will give it back to you in the interest of time, but that's my high-level comment.
We would be short of comments if we don't have Yao's response. He was trying to say something.
Sure.
Yeah, the floor is all yours. We were discussing on the issue of is it advantageous for the BRI, or is it I mean, whatever we discussed, is there a more advantage in the BRI arbitration, or is there a disadvantage that you could possibly see? And if there is a disadvantage, do you identify that itself could take hours and hours of discussion? But a 30-second response to that, would you have that? Mr. Zenche? I believe.
I can still hear that because wait a minute. Can you hear me?
Yes, I can.
Yeah,
hear
sorry,
you.
because Mr. Yao has some other issues to dealing with, so he cannot continue to join this discussion. And he just asked me to stay here and hear the discussion, but. I'm sorry, because I'm not a native speaker, so I can't catch the discussion. So I just have a little bit reflection about this talking. So can you repeat your question?
No, I was just asking whether I was assuming Yao was here because I heard him speak. Anyway, the question was considering all the discussions that we have had, is there an advantageous approach in the BRI arbitration, and is there more advantages to seek rather than the disadvantage? Is there more pros than the cons that we are seeing in the BRI arbitration? Especially for ad hoc arbitration?
BIR arbitration and ad hoc arbitration. Because, in my opinion, that I think ad hoc arbitration is much better than the institutional arbitration, because as I said, is the flexibility and the cost efficiency, and this gentleman mentioned that sometimes that if you go to the institutional arbitration, you have to choosing the arbitrator from the institution, and maybe there is a local arbitrator, so you cannot feel uncomfortable about that. So in that point of view, I think that the ad hoc is much better. But as we know that the ad hoc arbitration, the history is much longer than the institutional arbitration. But in China, that as I know that in our law, arbitration law, that is kind of forbidden about the ad hoc arbitration. I also wondering that why the kind of this kind of situation, and maybe I think that arbitration is not, not very well known in China, because when there is some kind of dispute, then maybe people will just go out to the court, not for asking for the arbitration. So in that point of view, that in 1995, that Chinese government have setting some arbitration institution based on its settings, like Guangzhou, Shanghai, Beijing, or some others. It's just like that. People don't know how to make the arbitration, especially the ad hoc arbitration. So we make this kind of situation. We have this kind of secretary, the assistant, to help people to push the arbitration. But the point is that we still, when they take the fee, and not only giving the arbitrator, but also give us the institute, and the fee, I think, is a little bit high, expensive actually. Although that the loser side were taking the whole fee, but it's kind of barrier for anyone to want starting this kind of thing. So now we're trying to because in 2016, as I know that the highest court have given some kind of permission that in some free trade zone that in China, like Nansha or some parts in Shenzhen, the very little zones, but the government want to encourage the economic commercial activities. So in that part, that we can allow the ad hoc arbitrations making, but as I know that is very little examples, because people are still not familiar with this kind of
Thank you very much, sir. If you could be kind enough to identify yourself, I do understand that you are not Mrs. Ensure. If you could identify yourself, we'll be very grateful.
What?
So if you identify yourself, we are conscious that you're not Mrs. Ensure.
Yeah, I'm not. Of course not. Because he got some other issues need to dealing with. Yeah. So I have to stay here. Sorry.
So if you could identify yourself, please.
Pardon?
If you could say your name, please.
My self introduction. My name is Liu Yang. Yeah, I'm also the officer in this institution, the National Arbitration Center. Thank you very much. Okay.
Very well. Adrian, I believe we have a few questions, but I don't think we have the time for those questions, because one of the questions was, is the solution for all of this, is a panacea mediation? That was a question that was asked by one of the attendees, and the panelists could respond, or if Adrian feels that we are so behind, we could take that question offline and possibly connect with the gentleman later as well.
Perhaps we can allow for a 30-second answer. What do you think, Dr. Srikan?
Yes, absolutely.
30-second answer?
Yes.
We do have the panelists, the topic 3 panelists on standby right now. So
yes, Kabir, you are great at telegraphic answers.
Sure. Mediation is great when parties want to mediate. If parties don't want to mediate, or one party doesn't have the true spirit for mediation, it will be a disaster. So, agreed in principle, practicalities question mark. I'm done.
Very well. Mrs. Zisheng? Yes, I was coming to you.
Yeah, me? I mean the last office. What's that supposed to do? You mean make a grammar or something?
No, we were just rotating between the panelists on the question of, is mediation the solution for this?
I think it's really a great way. Yeah, I mean, we can cut loose the distance elimination, and we can just face to face to have the talk. Yeah.
Sure. Mrs. Zensha, sorry, Mrs. Zisheng.
Mediation only work when the dispute amount is small. When the amount is big, it's difficult to mediate because the stake on the table is too big. So, and especially when the recommendation, or I would say the agreement by the party during the mediation is of huge amount, and the other party, whoever thinks that it's not getting a good deal, will say that, why should I take it? I must take my risk and going for the arbitration or the court litigation. So my own experience is, in fact, for construction dispute in Malaysia, there are hardly any dispute being resolved by mediation. Hardly any. Not that I know of. I tried being a mediator before, but it doesn't work. After halfway, the party feel that he's not getting the deal that he wants, so he just says, sorry, we're going to end it here and walk away. So my own experience, like what Dr. KB said, well, it's nice, but practical is difficult. Not for construction dispute involving big amount of money.
Whether the Singapore mediation, arrangement is not going to be happy with your comments on a lighter note. But Martin, thoughts?
Yes, I think as Kabir was saying, it's not a solution or a panacea all round, but with the right parties, the right time, the right dispute, then it certainly can be a valuable way of resolving a dispute. Also, it can be used, of course, in conjunction with arbitration. It can narrow issues as well. So I think there's real scope for it there. One has to be imaginative. It's not a solution in every case.
It would be highly uncouth on my part if I didn't do what I promised. Dr. Kabir Dugal is an attorney with the Arnold and Porter New York office. He's also a lecturer at the Columbia Law School, and he has been teaching. He's a faculty at the CIARB, which is a gold standard in this particular regard. And he also serves as on the Federal Republic of Somalia's NYC task force, or the New York Convention task force. Martin is a barrister. and has advised various states and corporations. He teaches LLM students on the ASEAN +6 at the College of Law, Sydney, and he is the UK's representative on the OECD Working Group on Bribery. We are pleasure to have Mr. Zi Xing, who is currently the managing partner in adjudication and arbitration. So I understand where the question on adjudication is coming from. And he has been arbitrator with the IAC. He holds a LLB, LLM, and a diploma in international arbitration from the CIRB. He's also one of the commentators on the Construction Industrial Development Board. Mr. Zinshia has been in the legal field and has served as the executive director of the Shipping Law Association, and we know his association with the NIC and other institutions. I cannot thank the panelists enough for the contribution. It was such a wonderful panel. I could just go on and on, but because of the paucity of time, we ended exactly at the 1 hour mark. Thank you very much for letting me do this in the 1 hour mark. Adrian, over to you, and looking forward to the further panels.
You're welcome, Doctor. What an insightful discussion on the BRI and arbitration. Once again, the Asian Institute of Alternative Dispute Resolution thanks Dr. Srikant, Dr. Kabir, Mr. Yao, Mr. Martin, and Mr. Lai for sparing time out of your busy schedules and joining us today for this forum. Unfortunately, due to time constraints, we have had to end the panel discussion. But for our next and final panel discussion, it is a panel discussion on the core values of ad hoc arbitration as a driving force for good, ad hoc as an elastic rubber, flexibility and cost efficiency. The Asian Institute of Alternative Dispute Resolution is proud to introduce our moderator, Dr. Shahriza, a legal academic and alternative dispute resolution practitioner. Dr. Shahriza read law at the University of Malaya as a recipient of the Public Service Department Scholarship. He graduated with a Masters of Law from the University of Malaya and holds a PhD from Monash University, Australia, with a thesis examining the World Trade Organization's dispute settlement mechanism. He was awarded a diploma in international commercial arbitration by the Chartered Institute of Arbitrators, UK, and admitted as a fellow since 2016. He is also a fellow of the Asian Institute of Alternative Dispute Resolution and the Malaysian Institute of Arbitrators, and sits regularly as an arbitrator and adjudicator in relation to construction claims pursuant to the Arbitration Act 2005 and the Construction Industry Payment and Adjudication Act 2012. He is currently acting as a senior lecturer at the Faculty of Law at the University Technology Mara, UiTM, Malaysia. Ladies and gentlemen, I shall now pass this forum to Dr. Shahriza.
Thank you, Adrian, for the kind introductions. Good afternoon, everyone. So before I start with the forum, it's my pleasure to introduce our distinguished panelists. I would like to welcome our panelists, Mr. Patrick Dam, Mr. Randolph Khoo, and Mr. Aaron Dowling Hassin. Now, before I move further, hello everyone. So before I move further, let me start with a brief overview on the topics ad hoc as an elastic rubber, flexibility and cost efficiency. Ad hoc arbitration is one which is not supervised or controlled by an institutional body. So if the parties and their lawyers can work together, then the process can be reasonably cheap and effective. A few years ago, I cut my teeth as an arbitrator in an ad hoc domestic arbitration relating to construction claims. And over the years, I found out that despite having some advantages, ad hoc arbitration has been underrated by the users of arbitrations. So the first issue I'd like to highlight is flexibility. I start with Mr. Randolph first. The primary advantage of the ad hoc process is its flexibility. So my question to you, what is the scope of flexibility that it provides to the parties?
Well, as the term implies, you're talking about complete autonomy in the most extreme case. of how you want to shape arbitration. You could have the rules shaped, you could have the number of arbitrators shaped, you could have the way in which the procedure is going to be shaped entirely and how you intend to do the arbitration. So I think the two most common factors you hear in terms of why people pick ad hoc arbitration tends to actually focus on cost and this factor of flexibility. Now, of course, the whole idea of arbitration itself stems from the autonomy of parties, and those terms that talk about the freedom to do a lot of things, I think gets its widest expression in ad hoc arbitration. Okay, so I think to that extent, when you're looking for the good side of ad hoc arbitration, then you're going to be talking about the flexibility to actually choose how the arbitration is going to be run. So I think that really, in terms of addressing your exact question of the scope, it's really how the entire arbitration is supposed to be run. Now, I don't know if, I mean, of course, when I make a broad statement like that, of course, there will be detractors from ad hoc arbitration as well, okay? For example, I think one would probably take a tea leaf read of the entire arbitral world and conclude that actually ad hoc arbitrations tend to be in the minority. I think what one can see is that there's been explosive growth of institutional arbitration. I read somewhere back in the early part of this decade that actually something like only 10% of the arbitral institutions that we have today existed before 1940. And I think if one looks back, from the historical fairness point of view of how long arbitration's been around, people pointing fingers back to the Peloponnesian War or even to the Babylon and so forth, where it used to exist, and one didn't see institutions in existence until maybe the 19th century. But right now, despite what one hears about the flexibility, you can do anything you want, essentially, that's what it means. Of course, I think the practicalities of that are probably what has generated the move towards reining in that degree of flexibility, okay? So another way of understanding the flexibility is that sometimes people don't like to be unguided. So maybe between these two extremes, hopefully I've really set the feel for what the scope can be. It can be perfectly wide, but people must be in a position to take advantage of that freedom. Or people may rather not reinvent the wheel and let others in institutions do the job for them, telling them how they should actually fight their case out.
All right, thank you, Brenda, for your view. Let me now move to Aaron on the second questions on flexibility. Aaron, in what circumstances would the ad hoc arbitration be more suited?
I think it's difficult to give a universal set of rules for that question. It very much depends on the background of the parties. So if you've got parties who've only ever availed of institutional arbitration and happen not to have formed a negative view of it, it's probably difficult for them to decide on a whim to try ad hoc arbitration. Whereas conversely, if you've got smaller to medium-sized companies who feel that institutional arbitration they're involved in was too rigid, too costly, went on for too long, it may be easier for them to say, why don't we try ad hoc arbitration now? Obviously, there are a certain percentage of disputes that emerge where there is no pre-existing dispute clause, and in those circumstances, it may be, that the parties find themselves looking at ad hoc arbitration. I'm inclined to believe where there's an existing dispute clause which sets out a roadmap that institutional arbitration will be used once the dispute kicks off. To sort of lapse into cliche, people don't agree what day of the week it is. So it's probably hard in many situations for both the parties with the backdrop of the dispute emerging to talk face to face and say, do you know what, we've agreed to use this particular institution. let's set that to one side and use an ad hoc arbitration. So it's sort of an issue as to the nature and history of the parties. And then more episodically, in certain situations, life takes over and the law doesn't catch up or keep up. So there may be sporadic moments where there are new disputes relating to technology or patents or pharmaceuticals, whatever it might be, where the law is evolving at such pace that it is very much the case that the parties decide that they want the freedom of a ad hoc arbitration because there's no history of institutional arbitrations in that area. So apologies for equivocating or sitting on the fence there, but it's difficult to be absolute on that one. That was me. That was my answer.
I hope we're not having a transmission problem there. The screen seems frozen.
I could hear you fine, Randolph. I'm not sure.
Yeah. Oops.
No, this is not how Charizard normally sounds, is it?
Yeah, I think we're having a here.
Ad hoc arbitration because of the budget constraint and a bigger multinational unlimited institutions. Oh, really?
Okay, I'm sure he's going to be dialing in again.
Yeah.
We've lost our moderator.
And so it seems
Hey, Adrian,
that
unfortunately, I think I can't hear you either.
Can you hear me?
Yeah.
And so it seems, I think Dr. Shah is having some technical issues. So
right.
Perhaps I could request, I can ask the panelists, any request for you to carry on with the panel discussion, perhaps too far away. Our team is currently getting in touch with Dr. Shah and we're trying to...
Yeah, I'm happy to. I believe that I was, unless I'm mistaken, I would have been up, or I am up next, isn't it?
Yeah, I think what we were going to hear from you was something about the cost efficiency of ad hoc arbitrations in the shipping industry, I think.
Indeed, because as as our moderator put it earlier, latest statistics show that ad hoc arbitration is actually alive and well, in London particularly, but not just in London.
Mm-hmm.
Indeed, within the context of the shipping industry. So obviously, in the context of this webinar, and generally the question arises, is it cheaper to arbitrate under the ad hoc than as institutionalized arbitration in shipping? And well, if I may share this first from a personal point of view, ad hoc arbitration indeed often seems to fly under the radar of the international arbitration community. I believe this is due to its nature, especially the lack of an administrative body interested in promoting its own function in commercial arbitration. But before I myself saw into the world of maritime arbitration, I didn't really know how popular ad hoc arbitration really is. I was aware of it, but I thought that after the advent of arbitral institutions, it had become a bit of a niche thing. Also because institutional arbitration has been given such an important role in the arbitration law of many countries. We alluded to that earlier, China. And because each arbitration location of standing, of course, has opened its own arbitral institution. But it's not a niche thing at all. I don't know so much about other special fields such as construction, but indeed in maritime, ad hoc arbitration outstrips institutional arbitration today, because the sentiment is that doing this without an institution and their rules gives you more flexibility and cost efficiency. Does that really mean, though, that ad hoc arbitration is cheaper? Well, yeah, to the extent that you save the fees of the middleman, the arbitral institution, which or who, as a middleman, may be preferred, as we have heard earlier, by parties who are relatively unfamiliar with arbitration or just don't arbitrate so often. For them, in institutional arbitration, or an institute rather, helps administer their case, but for a fee, of course. The result of that is obviously, where you have an assisting middleman, arbitration is not as cheap as without. But I have to reiterate what we have heard earlier, that cost saving will only be relevant if everything else works well. Means it puts a lot of onus and a lot of weight and relevance on the tribunal, who bluntly have to do it right. Welcome back, Shariza.
Okay, so I'm back. All right, Patrick, I have a follow-up question from that one. The failure of one or both parties to fully cooperate can result in time spent to resolve dispute through court litigation. So how to avoid such situation to ensure cost efficiency is maintained?
Failure of one or both parties to fully cooperate. Yeah, you're certainly right in saying that lack of cooperation in arbitration can result in time spent in court, but correctly, you didn't say that where there is an arbitration agreement in place, court proceedings can replace arbitration proceedings. Because in today's world of international arbitration, ad hoc or not, this is quite unheard of. I don't think you can fully ensure that no party will ever resort to the court even where there is an arbitration agreement in place. That's simply because most, if not all, arbitral laws give the parties legal remedy against the recognition or enforcement of an award before the courts. Cue the UNCITRAL Model Law and, of course, the New York Convention. So if there is legal remedy, some parties will try to make use of it, merit or not. And so situations like this can only be reduced in number. And this is again where workable sets of arbitral rules come in, even in ad hoc arbitration, based on a workable law of the seat, I would say. Because arguably, such arbitral rules make it easier for the tribunal to stay clear of these dangers, of the dangers that could lead to an award that's challengeable in court. But as I just said, the tribunal will really have to know and apply these rules properly. Those tasks, those administering and guiding and hovering above tasks otherwise exercised by an institution, will now have to be taken over by the tribunal. So yeah. Sharizal, are you still with us? It would seem he's not. Okay.
Well, maybe then we can go on to hear about, apart from cost, whether or not, you see any other advantages in the shipping aspect or industry where, one could use ad hoc arbitration as an attractive means of getting away.
Okay, I'm here to talk about shipping and maritime, right? And to take that angle indeed. Yes.
We heard about cost, so we're wondering if there's any other thing that would come to mind,
The users of maritime ad hoc arbitration are usually parties with more experience in arbitration and with disputes that often are relatively numerous, but yet very specific. Parties in the shipping industry, they dispute over ship sales or shipbuilding agreements, fuel salvages, charter parties, or bills of ladings and things like that. And with exclusions or limitations of liability based on international conventions or international rules, some of which exist in different versions. And without going further into detail, let me just highlight this. The Hague-Visby rules, whatever this is, anyway, have the force of law in Singapore, but only the 1968 version. In the United Kingdom, the latest 1979 version is applicable. In Germany, where I come from, none of that, but the original Hague rules of 1924 apply. So to give you an idea of what a specialized field shipping law is and disputes can be about. So when you are a provider of maritime, say, protection and indemnity insurance, then you may deal with a few of these disputes every year. So specific though. So this is a clientele that prefers the speed and cost savings, but also the confidentiality and the specialism that comes with direct access to arbitrators that are able to smoothly run ad hoc arbitration, right? And aside from enforcement issues, traditionally this is very much English law. So until recently, I would say, and questions of enforceability, say in China, in continental China, did not arrive so much. So nowadays we have heard about the necessity of a certain degree of institutional arbitration if you want to enforce that may differ. But traditionally, that is why ad hoc arbitration can actually be so strong in the shipping industry. Yeah. And hello again, Sharza.
All right, thank you, Patrick. I reckon that you have covered all the questions on the cost efficiency within the shipping industry. So let me go back to Randolph on the use of a tribunal secretary in ad hoc arbitration. So the use of a tribunal secretary can add some extra costs. In what circumstances the parties need to use the service of a tribunal secretary?
Okay. Well, I think one way in which we can approach this is to perhaps look at how useful tribunal secretaries have been. So I did a little bit of digging around, and White and Case and Queen Mary University of London does up these international arbitration surveys every year. And it turns out that from one of the surveys, it indicated that about 82% of international arbitration users have at some point in time employed a tribunal secretary. So it's pretty widespread. Looking further into the survey results, it turns out that really tribunal secretaries do perform a number of things, like, for example, organizational tasks, logistical arrangements, communications with the parties, even preparation of simple drafts of procedural orders, non-substantive points, okay? I think the majority of the feedback was that these were good tasks to delegate to them. In a sense, it would help the process because it would mean that the arbitrators are busy people. They don't have the clock excess hours in terms of their actual costs on the file. So one may then consider, well, then having a tribunal secretary, wouldn't that then drive up that other frequently heard reason why ad hoc arbitration is actually preferable, i.e. apart from flexibility, the question is, then is it not the question of cost being driven up? Well, I would think that actually from a cost perspective, tribunal secretary, in a sense, is a creature in which parties would have to actually consider in both forms of arbitration. There's nothing to stop an ad hoc tribunal from saying, I need a tribunal secretary to assist. And it's a matter really for consent, agreement of parties, and I see the economic advantage in doing that. So why not have one? And I think in terms of looking at the tribunal secretary just having to be an extra burden to the parties, well, I think one of the things that has emerged in the last few years, Queen Mary White and Case surveys, has been the call for regulation, really, of the use of tribunal secretaries. And it's interesting to note that in 21.5, the Singapore International Arbitration Center responded to administrative secretaries and imposed a limit on when they can be used. If the stakes are 15 million Sing and below, then only the expenses, reasonable expenses really of the secretary could be compensated. Well, if they went above 15, then it's open to the parties to agree both for fees and expenses, but there's a cap there of $250 an hour. So I think the recognition again is that actually, whilst it looks like an extra line item of cost, a tribunal secretary probably in the overall strategic cost picture help to save actually from the process, the overall arbitrator's costs. One major detraction from having a tribunal secretary, of course, is the question of his involvement. And I think that was also subject of litigation in England, came across a precedent before, where the arbitrator, I think, mistakenly then sent an email to the parties intended for the secretary. What do you make of P submission, something like that? And then it went to the English courts, and the courts actually weighed in to say that, well, because of the way in which the panel can do its work, as long as they weren't going to rely on the view of the secretary as a fourth arbitrator, there was really no ground for challenge to say that there's abdication of responsibility. But I think since then, again, I said, many institutions have responded to these calls for regulation and have issued their own guidelines of what the secretary can or cannot do. In terms of whether it adds significantly to ad hoc arbitration costs, I minded to think it wouldn't be a major cost component, especially when the parties get a higher efficiency return at lower costs instead of burdening the very busy practitioner or arbitrator who's actually appointed to decide on the case. Wow, I think this communication problem is going to be kind of dogging us to the end.
We're to go on to talk about guerrilla arbitration, I think.
Yeah, I think the aspect of abuse, right? Guerrilla tactics.
So I think actually that's me. So I'll pick it up at that point. Thanks, Randolph. So the issue we were asked to consider was to what degree does an ad hoc arbitration make life easier for a party who has decided they're going to be uncooperative and recalcitrant. So I've been rewatching a British comedy series from some years ago that was set in a school, and I'm reminded that somebody who wants to act the fool will ultimately do that come what may. So the safety net or difficulty that may be built into an institutional arbitration or could be adopted in an ad hoc arbitration to guard against guerrilla tactics at its extreme will not discourage the party who's set their heart on trying to disrupt the process. I mean, I think there's many people online now or who were online earlier who have what are usually called war stories from when they sat as an arbitrator, and the disruptive party often will surprise you with their degree of imagination. as to how to try and interfere with the process. So I'm not sure, as I say, at its extreme, whether the nature of how the arbitration is structured, whether it's institutional or ad hoc, will affect those parties who are trying to interfere with the process. So moving past that point, it may well be in some instances that there might be more of a reluctance from parties who are likely to be involved in a multiplicity of arbitrations over a period of time from flexing their uncooperative muscles in an institutional arbitration. There may be a concern that in reality, word will spread in the institution that this is the party that you want to really keep an eye on from the start because, of the approach to the hearings and that they wish to disrupt it. So it could be that concern doesn't arise in an ad hoc arbitration in the same way for obvious reasons. There's no corporate history in terms of a party who's involved in a one-off ad hoc arbitration, unlike in an institutional arbitration. But we're trying to second guess mad, bad, and crazy behavior, and by definition, that can be a little bit difficult. So those are my thoughts on the issue in any event. Thank you.
Okay. Let's see. I think Dr. Shah is still not on.
Yeah, I'm back. Thank you,
great.
Aaron,
Okay.
on the guerrilla tactics in international arbitration. So let me go back to you, Randolph. How to prevent, how to prevent the parties from abusing the ad hoc process? What is your view on this?
Yeah. Well, the key takeaway I think we can get from Aaron's couple of responses, actually, right up on the first one and until the most recent one, has been that actually you're looking at people who are having a backdrop of a dispute when the clause is called upon to do its job. To then do things as mundane as figure out what the arbitral procedure is going to be. And the expectation is that, well, if one side is hell-bent on making sure they get their way by way of delay or some other procedural advantage, they'll do it. So in an institutional arbitration, I think I take Aaron's point fully. One is to be careful that there's a blacklist that might build up, especially if the party is a frequent user of the institution. That's one deterrent that might exist. Then, of course, there's the issue about how people can actually try to address the inherent issues in ad hoc arbitration before the shooting starts. I think to take a military analogy, there's always a saying that no plan will survive contact with the enemy. So I think the same goes for no clauses surviving contact with the actual dispute. So one would probably have to make sure, I think in a setting like this, that the right skill set comes into play at the right time. And for this, I mean that most of our large firm setups, unfortunately, carve out the turf too close, religiously between the deal makers and the deal breakers. So my corporate colleagues who would be putting together the productive work, getting deals sewn together, toasting champagne glasses while at the same time trying to agree on a champagne clause, paying the least attention to how a bad news event might be dealt with, might be tempted to just put in a very simple line consistent with the flavor of everybody being amicable and happy now that the deal is done. I think that's how the odium associated with the disputes clauses has come about, the lack of thinking. So I think if we did have, though, involvement of the deal breaker, repairers, what have you, at that point in time, working with the deal makers to point out that the evil day may come, be prepared rather than sorry. then that might be a good way to start addressing abuse in an ad hoc arbitral clause. For example, let's start with the basic one. Even the seat of where the arbitration is going to be probably commands some kind of premium. After all, it's easily said, I think in many commentaries, that, well, if all else fails, supervising court, you've got a job. But nowadays, with the sophistication Aaron talked about in terms of how parties get around trying to make things difficult if they want to be, even the seat might be challenged. Which court is going to sort it out? And people spend oodles of time racking up far more costs than an institutional arbitration might be, just to figure out how to run the arbitration. So I think the first major prescription against abuse might be to pay some attention to how the ad hoc clause can be. I mean, if there's an aversion to any particular institution, sure, but there need not be an aversion to, for example, getting the rules of the institution borrowed. So that's one of the things I think that we can actually consider. That means, why not just adopt the rules instead of being administered by the arbitration if there's some stigma to be attached to the fee scale. Another way of then addressing it is also to perhaps not leave the disputes in the hands of maybe those who are less familiar with the legal world, because otherwise a lot of peculiar improvisations might occur along the way that might affect the eventual enforceability of the award at the end of the day. So I think ad hoc arbitration, while it has that virtue of being flexible, also requires, I think, to a very large extent, for it to be guided by a good hand. So I think that can come about if parties have experienced counsel on board when the shooting starts, or better still, get an arbitrator if they are sensitive to counsel costs, who's very familiar with how these things are run, and he can use his collective experience to fill in the gaps readily for the parties. So I think with these sorts of safeguards, it's likely that abusers might be trimmed down. A more firm arbitrator who is really not too concerned about reappointment prospects might well just take the bull by the horns, impose a realistic set of guidelines, procedures, and then get the case moving along. And in that sense, ad hoc arbitration can work. I do recognize, of course, there's a downside. If we are always on the hunt for experienced arbitrators, I remember not too long ago, there was a very peculiar arbitral forum entitled, "Why You're Not an Arbitrator Yet?" And one of the reasons tabled there was the unfortunate tendency of people to then go back to the usual crowd. But then that of course makes it kind of difficult for up and coming persons to actually occupy tribunal seats. But then again, those are industry problems. Well, I don't really want to cut into time, but I suppose that's how I would respond to addressing those problems of ad hoc arbitration.
All right, thank you, Randolph, for your view on the abuse of power in an ad hoc arbitration. The next issue I would like to address is the outer limits of flexibility. Let me go back to Patrick. My question to you, Patrick, should there be minimal considerations beyond a bare arbitration clause? Is untrammeled elasticity a good thing?
Is untrammeled elasticity a good thing? At first glance, you would like to say yes, right? Then again, I was exercising when I was thinking about this, so bear with me. When an athlete wears all his winter clothes, everything he has, then he will not make a good marathon or 100-meter dash runner. It's too much. Or yoga, or whatever it is. That doesn't mean, on the other hand, that wearing nothing makes this athlete a good runner, or a good tennis player, or a good yogi, you know? The tennis player still has to have a racket, right? So just a bare arbitration clause as such, with nothing else. Like if parties have nothing but a bare arbitration clause, like no more than the mere agreement, we shall arbitrate, then the chances of them coming to terms about everything they need to arbitrate after the dispute has arisen is very slim, as we have heard and as we all know. So yes, like an athlete needs the right jersey and the right equipment for his sports, an arbitration clause has to have something. An arbitration clause with some clothes on, so to speak, is recommended. Now, what and how much that should be, a full set of rules maybe, or mere parameters on the seat and how to select the tribunal, that is subject to debate and probably subject to agreement, and if the parties can find that out, or just delegate it to some set of rules. But blunt answer to your question, sheer untrammeled elasticity and by way of bare arbitration clause, no, I would say no.
All right, thank you, Patrick. I have a question for Aaron on these outer limits of flexibility. What minimal parameters are desirable? Is it the seat, the procedures, or the number of arbitrators?
I take Patrick's point on board with the sporting analogy, that before addressing the question, we have to look at how would we get there. So the issue is there's either a dispute clause, which isn't very good because it just says something along the words Patrick used, that we will just have an arbitration, or perhaps more likely, there's then no pre-existing dispute clause and an issue has arisen between parties, and they discuss how they will resolve it, and they agree upon using ad hoc rather than institutional arbitration. So in those circumstances, who sets those bare parameters? By definition, when you're not using an institutional arbitration and you have no existing dispute clause in your contract, or you have a arguably unsatisfactory dispute clause with very, very little detail, you're then in a binary discussion where one side can't really set down the law, so to speak, to the other side. It's an issue where both parties need to progress and move the matter on. So I would think in an ideal world where you have people who have an idea as to what they've got into and the complications that might arise, I think you certainly need the parameter of the seat. Now, whether you need anything beyond that, I think it really depends on the background of the dispute, the nature of the parties who are in dispute, their pre-existing experience and history of disputes, and the specific industry dispute that arises. So thank you. That's my response to that one. And I think we're on our own again for a moment. So I think Randolph is to look at administrative fees.
Cost considerations.
Yeah.
Okay. Well, okay. I mean, there was the other point, I suppose, about fees being the problem really of an institution. For that purpose, maybe what I can do is I could then in this situation try to share the screen with a little set of slides that I got. They might just do the discussion for me or help it. Okay, for that purpose, let me try to get it up. Okay, there we go. All right, I have here a series of slides. And one of the things to notice is that for each arbitral institution, You have the kickoff fee, okay? And I think we've listed them there, the SIAC, ICC, LCIA, Hong Kong, and so forth. Not sums that would drive parties in the impecuniosity, but there we are. Then we've got administration fees. And I think the majority tends to have ad valorem scales, although LCIA and Hong Kong is an opt-in mechanism for hourly or ad valorem scales. And looking at them, there are also certain caps really to how much they can be. And you can see that there they are hovering at 95,000 Sing dollars, about US 72, ICC at a 150, LCIA being by hours, HKIAC 51, and then the highest one being CTEC. Okay. And just to give an idea, the fees also have a certain proportionality, obviously, in relation to the sum in dispute. So there's some method to the madness, especially when one looks at the huge sums in dispute at the end relative to the amount of administration fees actually being incurred. Ditto for CTEC, despite having the higher end of these fees. Okay. Now, at this point in time, then, I suppose the analysis of how punishing really these institution fees are, such that it becomes one of the major talked about factors, then has to be looked at in terms of how much really the parties spend on their legal costs when they go into battle in institutional settings versus ad hoc. I looked around and found a 2015 ICC Commission report. I think it was intended, of course, to indicate that, look, while admin fees are part of life here, they don't really sap life out of the entire arbitration. So they classified costs into three major heads. And I was quite surprised to read the breakdown. It turned out that 83% of the parties' arbitral costs actually went towards representation costs. So the legal profession was the largest benefactor, essentially. Then the arbitrators would take something like an average of 15%, turned out. And the administrating costs of the ICC turned out to be 2%. So if one takes that perspective and asks whether by going ad hoc, what have we really saved? Sometimes one wonders, you're saying 2% goes out the window, okay, sure, but at what price? At the price of the case not being properly monitored, the price of the award not being reviewed or scrutinized before it's being issued for enforceability, at the price of uncertainty of rules, a claimant eager to get on, a defendant willing to do what Aaron discussed in terms of guerrilla tactics and holding things up. The cost generated there is likely to then bump up that 83% into far more costs that cannot be seen from an arbitral perspective because they're spending court. So I think really when one talks about, the key point, I think when we talked about having this as a point of discussion, it was discussed in terms of admin fees being a bane of an institution. Maybe if institutions did some sort of cost analysis like the ICC, it does, I think, help give a healthy dose of skepticism over the kind of criticism. And really, I think when one looks at institutional versus ad hoc, the real question is whether people are capable or people are willing or in a position to do what some skeptic might say is reinventing the wheel every time a dispute occurs, or whether we're better off letting the rule makers who have the experience of administering and seeing problems and are responsive to them come up with a regime that might benefit us. Who are just so sucked up in real life disputes every day, there's little time for reflection and coming up with workable rules that actually help parties. I think one example might well be early disposal. I remember fighting tooth and nail just about a few years back, trying to get an early award on various aspects of a dispute, and then confronted with the fact that commentaries were saying that that sort of approach might detract against finality of such awards and possibility and so forth. And of course, there's a natural reluctance of an arbitrator to then render an award before the main event has occurred. But nowadays, it's becoming more par for the course to find that many institutions want to be progressive, they want to be responsive to user needs, and they're looking at issues like that, consolidation of proceedings, and so forth.
Thank you, Randolph.
Yeah,
Randolph, sorry, I have to cut you short because we are running behind schedule.
I'm so sorry. I better watch the clock better. Yeah.
One last question to Aaron before we conclude the session on the administrative phase. Aaron, is it desirable for the parties to switch to ad hoc arbitration despite having a specific provision for administered arbitration in the contract?
I'm conscious that the Vice President is waiting to close the event and that we have overrun, so I'll be quite brief, if that's okay. It could be, but in my experience, the vast majority of parties lack the imagination to go there. So it can be something that in particular disputes should be followed, but just the rigidity, the backdrop, the psychological side of how people respond once they're in disputes, it's hard for people to take that step.
All right, thank you, Aaron. So before we all sign off, allow me to deliver some concluding remarks on the topic. Whether ad hoc or international arbitration is preferable, we always depend on the dispute in question. And many arbitration users have a strong, and these parties will continue to be attracted by the reputation, familiarity, convenience, and transparency of a leading arbitration institution. However, ad hoc arbitration also has its advantages, and many of the apparent disadvantages of ad hoc process can be mitigated by a robust tribunal with strong case management skills. Parties preferring the flexibility of ad hoc arbitration will welcome the latest clear indication that ad hoc arbitration continues to thrive. So this brings us to the end of the session, and I would like to thank all the panelists for their insightful views and the participants for their interest.
Thank you very much, gentlemen.
Thank you all.
Thank you.
Even when faced with unexpected technical difficulties, we would like to thank the panelists and moderator for carrying on with the panel discussion without delay or hesitation and ensuring the continuity of the discussion. Once again, AIADR wishes to express our appreciation to Dr. Sharizal, Mr. Aaron, Mr. Patrick, and Mr. Randolph. We are grateful for the time and effort you took to share your thoughts and experience on arbitration and ad hoc arbitration in particular. We were fortunate to have a wide range of panelists from all arenas. It is our collective thoughts on promoting ad hoc arbitration and its best practices that will bring us closer to advocating ad hoc arbitration. This forum was not meant as a single event, but as a great initiative for future collaborations and the advocacy of ad hoc arbitration. I would now like to invite Datuk Kwek Yiming, the Vice President of the Asian Institute of Alternative Dispute Resolution, AIADR, to deliver his closing speech.
Thank you, Everett. Good evening, Excellencies, distinguished delegates, ladies and gentlemen. It's a great pleasure for me to say a few words at the end of this very constructive forum. On behalf of AIADR, I would like to firstly extend our sincere appreciation to the respected guest of honors, Tan Sri James Wong, former Justice of Federal Court of Malaysia, and IR Chu Kok Beng, the champion of professional services, productivity nurses, Malaysia Productivity Corporation, for gracing today's forum with their words of wisdom. Their acknowledgement and endorsement of AIADR is indeed a great boost for us. This event would not have been successful without the lineup of stimulating panel discussion, as the moderator has pointed out just now, that we have witnessed today. We are deeply grateful to all the distinguished panel speakers and students whose participation has reached the forum. Our utmost gratitude goes to all our sponsors and supporting organizers, among others, Chinese Arbitration Association, University Technology Mara, Malaysia Productivity Corporations, Hainan International Arbitration Court, Zhejiang Legal Plus, Thailand Arbitration Center, Associated Chinese Chamber of Commerce and Industries of Malaysia, Kovais Foundation, Conflict Resolution International, Hainan University Law School, Nanning Arbitration Commission, Nanning Lawyer Associations, China ASEAN Macau Arbitration Association, and Malaysia Hebei Chamber of Commerce. And one more, the soul behind the scenes, whose enthusiasm and resourcefulness has brought us all together today to engage in this very timing conversation on ad hoc arbitration, President of AIDR, Dr. Professor Sudaraju. Thank you. I'm certain that various dialogues today have helped us to explore the applications and development of ad hoc arbitration as a medium which not only resolve dispute, but also act as a cost-efficient alternative to the institutional arbitration in the midst of COVID-19 outbreak. In view of implementation of various movement control order and complete lockdowns, it is inevitable that most of the businesses are struggling to survive financially, and some may be facing insolvency, given that ad hoc arbitration provide party flexibility in choosing their ways to conduct the arbitration and does not require them to pay administrative fees. It is likely that the companies may choose ad hoc arbitration to resolve their dispute as compared to litigation or institutional arbitration, which is much more costly. Further, ad hoc arbitration may be rather time efficient than the administer institutional arbitration if all the parties cooperate and facilitate the arbitration. Thus, it is then important for us to have the knowledge regarding the ad hoc arbitration and its present issue, which we may face together at our fingertips. Further, as mentioned by Tan Sri James Fong in his keynote speech this afternoon, the COVID-19 outbreak has drastically affected the legal fraternity. It has caused massive changes to the conduct of delivery, legal services. Virtual hearing and the manner of dealing matters remotely are introduced hand in hand with new legal facility to accommodate the overwhelmed need of legal help. We have no choice but to accept these changes and new norms and adapt them swiftly in order to ensure that the delivery of justice is accessible and efficient. Therefore, in launching our AIDR ad hoc arbitration rules, we genuinely hope that such rules will help to ease the burden of the disputing party involved. We also hope that today's forum will provide our members an important insight into the use of ad hoc arbitration. Besides that, we'd like to thank Tan Sri James Fong again for acknowledging our hard work on the initiative of ad hoc arbitration on appointment, case administration, and financial management. Thanks from ITCO as well. In line with this development, AIDR is all the more determined and equipped to play its role of promoting ADR practices by promoting cost-efficient, accessible, and accredited education and training to the profession across the globe. As a founding member of IPACSO, i.e. International Commercial Dispute Prevention and Settlement Organization, AIDR will continue its effort to intensify the promotion of ad hoc arbitration with our AIDR ad hoc arbitration rules, making a start of this journey. Ladies and gentlemen, the COVID-19 pandemic has, at its best, intensified adaptation in all of us. And with AIDR, through its program and initiative, is determinedly on its way to facilitate efficient dispute resolution and prevention. And we would like to welcome with open hands any form of collaboration that will lead us to play a role in improvising ADR practices and facilitating international trade. Together, we will prevail. On that note, I shall mark the end of this forum. Thank you for all the attendees. Thank you.
Thank you, Dr. Quek, for that wonderful closing statement. On that note, on behalf of the Asian Institute of Alternative Dispute Resolution, we would like to thank our distinguished guests and all participants sitting in with us for your valuable contribution and participation in this important forum. Distinguished guests and participants, kindly be informed that we will be having a networking session. You may find the details of the Zoom meeting for the networking session on the main shared screen shown now. For members of the AIADR attending the annual general meeting, kindly be reminded that the annual general meeting will be starting in a short while at 5 p.m. Malaysian time. And as for the rest of our guests and participants, please feel free to join and start socializing again on an ad hoc basis. I shall end the forum, and don't forget to check out for more information on our website or our social media. Thank you and have a great day.
Thank you.